I beg to mention item number 20 of today's lesson. The matter has become in progress.
Item 20,
20, 20.
the request of the PSB and the company, who submits that on instructions that the matter has become in practice. The petition stands dismissed as in practice in primordial pending stands vacated. Pending ayes are open.
All right.
May please, Your Majesty, I beg for item number 25 of today's list, my lord. Honorable God directed to produce the record, my lord. Kindly then fix the matter immediately after vacation, my lord.
Who's for the respondent?
Yes,
Who's for the
I have already informed R. Mozumdar, my lord.
25 is the request made by MSA Gayon, matter stands deferred to be listed in the third week of July. On a date to be fixed by the race.
Master.
May I please, Your Lordship? My lord, I beg to mention item number 22, Your Honor. The engaged counsel is having some personal difficulty, Your Honor.
Item
Maybe
22
adjourn for
on a request made by Mr. Saiwala, GN Saiwala. The stands deferred to
M.
be
Sahib.
listed after 4 weeks. M. Saiwala.
Date may be fixed.
After 4 weeks on a date to be fixed by the race.
Please, Lordship. Lordship, I beg to mention item number 23, Lord.
Yeah.
London Council G. Bordolo, he is suffering from cervical strangulitis, Lordship. So matter may be adjourned for a day and fixed on 14.
Who's for the petitioner?
My lord, I
Any objection? On a request made on behalf of Mr. G. Bordolo, counsel for the Corporation Department. That Mr. Bordolo is under medical leave. Matter stands deferred to be listed after 4 weeks. Mr. S. K. Chakraborty appears for the petition. Please after 4 weeks.
Obliged.
May please, Lordship. I is filing item number 30 is not attached, my lord, a requisition slip.
IA
Means, my lord, item 30, my lord.
30.
Yes, I is a requisition slip.
May I plead your lordship? Lordship, I beg to mention for listing, my lord, after vacation any date. Compassionate,
After vacation. You mention it after vacation. Why are you mentioning it?
my lord, before vacation, if possible, my lord, allow, my lord.
What matter?
Compassionate apartment matter, my lord.
Admission, motion.
Admissions, stay.
Admission will come after vacation.
My lord, 18th of
All right, 18.
public.
May I please, Your Lordship? My lord, I beg to mention item number 29, my lord. My lord, in this case, the petitioner have already died. You have communicated with his only son, my lord, but he's not interested. So, my lord, I want to not praise that case, my lord.
It's the T6
Sure.
Planet Council for the petitioner on submits that the writ petitioner expired to the validity of the writ petition. His legal heirs, upon being contacted, has expressed
Right.
their have not expressed their desire to pursue with the litigation any further. Have you received anything in writing?
Not any writing, my lord, any other case also
These
pending.
instructions have been communicated to the petitioner verbally. He therefore submits on instruction the writ petition be closed as not pressed. Taking into consideration the submissions made, writ petition stands closed as not pressed. In primordis, the many stands vacated pending ayes are open.
My lord, obliged, my lord.
Item number 12 and 13, both are analogous method. In item number 12, I have filed an IA, but for implement, some inadvertent error has crept up, my lord, and therefore, my lord, I am praying for withdrawal of the IA with a liberty to file a fresh.
Item 12.
Item 12, my lord, I have filed an IA for
And
implement.
13.
13 is analogous, my lord. 13 in item number 13, my senior.
Item number 13, my lord, make that I am paying for the speaking up this matter, my lord, because of the tendency of this repetition, my lord. I am not getting my salary for the post which I am holding, my lord. Long make, in fact, the matter was hard, my lord, by a coordinate bench of this honorable court, my lord. Because of the tendency of this item number 13, my lord, the matter could not be finally disposed of, my lord.
We will fix it after vacation.
My lord.
So both the matters will be hard together, my lord, because it is analogous.
In item 12, in IA number 2032,
Lordship.
Yes.
2025, the counsel for the petition applicant submits that some inadvertent errors have crept in. Therefore, seeks liberty to withdraw the same and file it afresh. Prayer made is not objected to by the respondent. The IA stands dismissed on withdrawal with liberty.
Sure.
And then you write item 12, WPC 7626 and item 13. Be listed together. On
Can it be, my lord, immediately after the occasion, my lord?
immediately after the session. Hello. 23rd. 23rd.
Can it be on 18, my lord, 18?
18 or 18.
No. Obliged to lord.
In both the case, I am paying for the SCRT.
Mr. S. Bora appears for the respondent who does not appear.
Certified to detect the matter, it will come up together, my lord. Both times. Lord, I'm obliged.
My lord, in this case, the last order, as per that order, my lord, I have to find out the correct address, but I tried, my lord, level base. But there was no any source to came to know, my lord, the present address of the respondent number 4. But so far, the, my lord, the other official respondents are concerned.
Lord, I,
They can provide the address because they know very well now where the man is posting, my lord. And it is retired also, his address because the is he retired.
Item one, can it be taken after some time, Lord? Vijita Sharma, she is appearing, Lord. She is stuck in.
Time no time. All steps are done.
Okay.
Who saw the respondent here?
Respondent is a private. Actually, my lord, there is no any relief was sought against him, my lord. My prayer was that, my lord, he was junior to me. So, my lord, my promotion should be considered over his death, my lord. Date of promotion. That was my relief. I sought for. But there is no any, my lord, relief was sought that hampering his any post he is enjoying. Not on that.
You are in service or you retired?
I am in service, my lord.
So he also must be in service.
But the address is difficult to find out because I try to get the things from the office. There nobody is, my lord, responding. So, my lord, they are the best person to say by the official respondent. They can provide the address. my
Right.
lord.
We'll call up after a while. Who's appearing here?
No, Vijita Sharma.
Later, some
She's more.
time. being.
May please also. My lord, as per Lavazima Court's order dated 3/1/25, my lord, service upon respondent number 9 has been completed, my lord. My lord, here records is, my lord, required, this honorable court wide order dated 11/2/2021 Q1, my lord. A record pertaining to the service of the husband of the petitioner has been called for, my lord.
As per Consumer Court order. Dated 3/1/25, service on respondent 9 is complete. Let the matter be listed for pleadings are complete.
My lord.
To be listed for hearing. Issue rule. In the
My
meantime,
lord, can it be on admission stage, lord, may this.
the respondents will produce the relevant records relating.
Record received, lordship.
You have received the
Received.
in terms of the earlier order dated 15/3/21, the relevant records relating to the service of late Tilok Hona, Supervisory Kanung Board, the office of certain officer who expired on 26/2/2012 was received, has been received. Matter therefore be listed for hearing on 17 July.
I'm for 4 and 5.
If there are more appeal to.
Can it be, my lord, on 22, my lord?
22 already. It's on 22. The official records will be retained by the government advocate to be produced before the court on the next date of listing. So if the need so arise.
Lordship.
Yes, Lordship. Lordship, the matter has become instructive.
Counsel for the petitioner or instruction submits the writ petition is legally practice, therefore stands dismissed as in practice. Interim orders, if any, stands vacated, pending ayes and also.
The lordship. This matter has become infruction of
Council for the.
there was order that was passed.
That the writ petition has become instructed. Therefore submits that the petitioner does not wish to proceed with the writ petition. Ordered. Accordingly, writ petition stands dismissed as in practice. Interim orders, if any, stand vacated. Sir,
K.M. Hassan on behalf of DC Bora, my lord.
for the
Respondent number,
respondents,
yes, 1 to 10, my lord.
the DC.
My lord.
volunteers for the respondents.
My lord, the interim order may vacate, my lord.
Interim orders passed early, it stands vacated.
Abolished, my lord.
Pending ayes also dismissed. Pending. On appeal for the petitioner on call. One is appeared for the writ petitioner when the matter was called up earlier on 31/7/2019 and 13/12/2024. It appears that the writ petitioner is not desirous of pursuing the writ. Accordingly, the same stands dismissed as not pressed for non-prosecution. Interim orders, if any, stands vacated. Pending ayes are also dismissed. Mr. J.K. Goswami appeared for the respondent.
All the respondents.
In six, I am appearing, my lord. The quantum, my lord.
Here,
The judgment was passed in 26/22, directing them to release my salary, give my full salary.
May I please?
They preferred a review petition dismissed, appeal, table preferred, table dismissed, my lord.
May I please?
Only two is now they are bound to implement the order.
yes,
Pass over for the time being, Mr. Dinant will appear in this.
time being.
I think I filed IA, my lord, for correction of, my lord, implement of respondent, my lord. Wrongly typed, my lord.
Correction of
Correction of, my lord, first title, my lord, Department of Health and Family Welfare Department, first type, my lord. For it has to be, my lord, Water Resources Department.
water resources.
Yes,
That is respondent number 1.
yes, my lord.
This IA has been filed by the applicant petition, who has filed the WPC number 5034 of 2023, praying for a direction for consideration of its case for appointment in question round by the under the Water Resources Department. So, counsel for the applicant / the petitioner submits that by oversight, respondent number 1 was shown to be State of Assam, represented by the Assam Health and Family Welfare Department, Assam, when the appropriate department should have been the Department of Water Resources,
Yes,
represented by Commissioner and Secretary.
yes, my lord.
Commissioner and Secretary. He submits that the state error crept in inadvertently and was not noticed until after the order dated 193 was passed and steps were required to take. Accordingly, this IA has been filed seeking liberty to correct the array of parties, more particularly that of respondent number 1 in the course title, as is appearing in WPC number 5034 of 2023. There Mr. J.K. Goswami, senior government advocate, and Mr. C. Buragwai for
Water Resources.
Water Resources Department, Mr. J.K. Goswami for
2 and 3, Lordship. State level committee and district level committee.
state level committee and district level committee do not object to the prayer made. So, according without giving notice, this IA at this stage can be allowed. It is ordered accordingly. The IA stands allowed. The respondent number 1, the array of parties in WPC 5034 of 2023 will be read as State of Assam represented by Commissioner and Secretary, Department of Water Resources. Where is the office located? Dispur,
Dispur, my lord.
some Dispur point 6. Instead of Commissioner and Secretary, Government of Assam, Health and Family Welfare Department, Assam, Dispur point 6. Let the petitioner file an amended course title to that effect within 2 weeks from today. This order passed today in the IA shall be read together with the order passed in WP order dated 1/9/2023, passed in WPC 5034 of 2023. Copy of the said order be retained in the case records of WPC 5034 of 2023. I accordingly stands allowed, disposed of. In the main writ petition, you write, in view of the order passed on so and so today's date, in IA number so and so, petitioner is allowed to file amended course title for correction of the name of the respondent number 1. So, in place of respondent 1, in place of State of Assam represented by Health Commissioner and Secretary, Department of Health and Family Welfare, the same shall be read as State of Assam represented by Commissioner and Secretary, Department of Water Resources, Assam, Dispur 46. Matter be listed after the applicant petitioner files amended course title is done.
Let's
Yes,
highlight
they file their, complete their instructions and file necessary amendment.
Lordship, extra copy may be required.
Extra copies of written
already
is I will serve
already given.
That's right.
within 2 working days. I'll be counting to verification.
Okay.
You file, you serve copies of the IA also.
Your Lordship. Instruction was called from the council for response number 6.
So what is this IA for?
I will not press the I because I have already received the family pension. Only my grievance is that DPF is not received by the.
IA number so and so filed by the applicant petitioner for direction to continue payment of provisional family pension is not pressed, as the petitioner has subsequently received the family pension.
Yes.
Provisional or regular?
Regular program.
Regular family pension. Accordingly, IA has become infractious. Same stands dismissed is not pressed.
I released, I got all the pension benefit except the GPF.
Yes.
GPF amount. Yes.
In WPC number so and so, right, it is submitted by the petitioner that he has received all payments, including,
Well, I've got the instructions, my lord.
you have,
Excluding GPF.
That I have already handed over. But the proposal that has been submitted to the office of the AG is not in the format, my lord. It's required to be submitted in a form, but they've submitted in a plain paper, my lord.
submit.
The block elementary education officer, probably, my lord. Education department. No, not the block elementary.
Video.
PNRD department.
BDO is the PNR.
BDO, my lord. PNRD.
Response number 7.
All right.
But,
The WPC, you write, is submitted by the council for the petitioner that all payments and benefit, retiral benefits receivable by the petitioner has been received except the amount
GPF.
standing under the head of GPF. So, on the earlier occasion, the respondents were directed to complete their instructions. Today, with the matter is called up, Pratik Sharma, learned counsel representing the accountant general, placed before the court a communication dated 19 June 2025,
It's 16 June, my lord, dispatched on 19.
16 June 2025, addressed to the BDO, Hemaji Development Block, requesting for resubmission of the final payment application in respect of the husband of the writ petitioner.
Yes. Already earlier three occasions were submitted.
Chandra Bora, holder of GPF account number CD 8083 for early settlement. Stop. This communication was addressed as the GPF proposal, as the proposal for release payment and settlement of GPF account in respect of the husband of the late petitioner was submitted in plain paper and not as per the format required. Para Mr. Who is for PNRD?
Lordship, A.K. Ghosh on behalf of Mr. Anta.
Yes, what do you have to say?
Since the proposal has been sent again, so we'll communicate it.
Your Worship, earlier also 3 times the proposal was sent by the BDO.
It was sent, my lord. I'm not
Three
disputing.
times.
But not in the format, that's the problem.
You get instructions today is Tuesday, get it by Thursday. You get it by Thursday. Give him a copy, photocopy. What steps you have taken? Mr.
A.K. Ghosh.
A.K. Ghosh, representing the PNLD department, is permitted to obtain his instructions with regard to the status of steps taken by the BDO, Hemaji Development Block, pursuant to the communication dated 16/6/2025. Let the matter be listed on Thursday. Copy of this order be marked to the office of the Standing Council PNRD for onward communication.
Can it be after the vacation, my lord?
After vacation,
My lord, because my lord, lordship knows I will not be available on Thursday and Friday.
okay, list immediately after vacation on 16th July.
My lord. I dismissed.
May I please your lordship? Should later pertains to appointment of Gram Pradhans. But your lordship, in this case, your lordship, earlier judgment of this
Why did you file the IA?
IA to impeach Director of Land Revenue Lordship as a party, but that case is pending before that forum, your lordship now.
Huh?
And that now this instant case is pending before Director of Land Revenue, your lordship, for order, your lordship. So it become already my purpose has been met, your lordship.
Counsel for the applicant submits that the prayer made in the IA is not required to be pressed any further accordingly. The IA is dismissed as not pressed. Yes, now
And WPC also should maybe withdraw, your lordship. Because,
Withdraw?
yes, because the case is pending for order, your lordship.
right.
Before
The council also makes a similar prayer in respect of WPC number so and so on the ground that the matter is pending before which authority?
Director of Land Revenue.
Director of
Land Records.
Revenue. For deciding the appeal,
Appeal, lordship,
deciding the appeal preferred by the petitioner.
with petition.
The matter as informed to the council of the petitioner is now ready for delivery of orders. And the order is likely to be delivered within a short date. Under such circumstances, counsel for the petitioner submits that the writ petitioner does not wish to press the petition any further. Accordingly, same is then dismissed, has not pressed. Interim orders, if any, stand vacated.
Sure, please.
Make to you, my lord. The IA, they filed their response yesterday evening, my lord.
There,
And they filed their response yesterday evening. Have to go through it, my lord, let the matter come on immediately after vacation.
counsel for the petitioner submits that he is in receipt of the objection filed by the filed by the respondents of the party in the IE. He therefore submits that the matter be listed after vacation, enabling him to complete in the IE. That's point five. Based on 18.
Interim order has to be continued.
Interim order passed earlier will continue.
Deep level.
Next week.
Wait, please, sir, also. My lord, as per the last order, my lord, the lordship directed us to effect service of Dusty as well as AD card, and we have effected Dusty as well as AD card service. My lord, regarding the Dusty service, we have filed an affidavit on 23rd. Now, my lord, in the meantime, my lord, the respondent number 4 has filed an affidavit in opposition. That is the personal department. My lord, we need some time to go through, and your lordship might kindly give us at least 1 week time.
When did you file the affidavit?
Yesterday, my lord.
It is not on record.
Counsel for the petitioner submits that in deference to the order dated 3005 steps were taken on which respondent? 6.
6 members.
By registered post 80 as well as equal reports. Dusty service was also effected. The affidavit of compliance was filed yesterday.
23rd.
23rd. 23/6. And the same, therefore, is not connected to the case record. Well, who has filed an affidavit?
My lord,
Respondent 4.
number 4.
It is also submitted. Respondent 4 has filed an affidavit to which the petitioner would like to file a rejoinder. Petitioner prays for 4 weeks.
My lord, 2 weeks time, because
2
my lord,
weeks.
yes.
Time to
After
file the rejoinder list after 2 weeks.
I'm for respondent, my lord.
My lord, can I pray for a
Thesis Bhutia, additional senior government advocate. Appears for respondent 4.
4.
P. Sharma 4.
5, Lord.
Respondent 5. Yes,
my lord, can I pray for fixed date?
fixed date.
My lord, because the issue was that the provisional pension has also not been released till.
21st
My lord.
July.
Okay.
21st.
21st July.
Yes.
Of like.
Deeply.
None appears for the petitioner on call. None had represented the petitioner when the matter was last called on 31/7/2019. Mr. Sen here, Mr.
The PNID, Lord. AK Ghosh.
A.K. Ghosh appears for the respondent, PNRD department.
Sorry, my lord.
Yes,
Matter infractions.
Mr. K.J. Sadma submits, A.D. Sharma submits that matter has begun practice. Accordingly, the same stand dismissed as not pressed. As in practice, the interim order remains stand vacated. Pending eyes are also dismissed. Mr. Ghosh for the respondents. Yes. That appears for the petitioner on board. Anyone for the industry department? Any instructions here? No. Salary paid, not paid?
I have no instruction regarding that. I'm not to finance department. Appointment of the petitioner was cancelled.
Accordingly, Mr. N. Polita appears for the industries department, Mr. A.K.
Deputy Commissioner.
Probably appears for. Yes, Mr. Nayak.
Lordship, in this case, initially an appointment was made,
It was
subsequently it was dismissed. Then on intervention of this honorable court, when the order was faced, termination order, Finance Department took a decision to, approve the appointment, Lord, SIU.
Then
But subsequently, Lordship, when court again passed an order, Lordship, asking to file an affidavit, how a person whose appointment was made in violation of the constitutional provision can be given salary from the state executive. Then Lordship, file was forwarded to the judicial department. They gave their view, Lordship. They asked the finance department to review the earlier decision. Accordingly, we reviewed and we cancelled the approval granted in the year 2014, Lord.
that is not under challenge.
That is not under challenge.
Is it available on the record somewhere? The
Most
information?
probably, we have not filed any affidavit. I am saying this is an instruction even of 2020 itself, Lordship. And I found no affidavit has been filed, Lordship, by the finance department. So if Lordship permits, Lordship,
You bring that on record.
Lordship, Lord.
It's not appeared for the. But we tested after 4 weeks. Meanwhile, as it is submitted by the Standing Council Finance Department, Mr. E. Nayak, that the appointment of the petitioner upon review by the Finance Department has been cancelled. Let the cancellation order be brought on record. Or placed before the court. List after 4 weeks.
4 weeks. Obliged, Lord.
My pleasure, Lordship. But in this matter, PTC has not filed their affidavit yet, my lord.
Are you
Was not
pursuing
filed.
this case? It has become infructuous, I think. Lordship, this is a matter, Lordship, wherein the appointment of one IAS officer as administrator of BTC was challenged. And this appointment was in the year 2018-19, Lordship. Now thereafter election took place, Lordship, government came into power, Lord.
No,
Not that appointment is no longer there.
But my lord, they are still in service, my lord, and status quo is also there.
Service means he's a IAS officer.
I think.
What is your prayer here?
আজিগুলো আছে এটুয়ের একটু বেলেগ নেই কিছু বড় হয়
No, this is something else. These are grade 3, grade 4.
Yes, my lord, this is different, my lord.
You are praying for the direction not to remove them from service.
Yes, my lord.
বেলেগ ফাইল দেখো
Yes, what is your prayer?
My lord, they have not filed their affidavit, let them file their affidavit, my lord.
এইটাকে ফাইল করে না Lordship, I took another file, Lord.
Mr.
J. Das, my lord, on behalf of MSD.
For the petitioner, Mr. P. Nayak.
I'm for BTC, Lordship.
Yeah.
1226, Lordship. 23456.
23456.
I prepare for respondent number 1.
Ms. D appears for N day.
Yeah.
Appears for respondent number 1. The respondents have prayed for further time. to complete their inspection and file necessary affidavit. But they approved be listed after 6 weeks. The interim order passed earlier will continue.
I'm obliged.
I'm sorry.
Actually, I am for the respondent. Actually, this matter is, bank has invoked the surfacey matter. So if they want, they may file appeal before the DRT. That in Mardia case, as well as this,
They are
Okay.
making allegations of fraud.
not fraud.
None appears for the petitioner. Vote. Appears for- Are you filing any affidavit? You filed.
I have filed affidavit.
Respondents have filed their affidavit.
Yeah.
However, no rejoinder affidavit is not filed by the commission. Purely for general justice, the matters that referred immediately after review. We are deferring it since there is no counsel to the petitioner after vacations.
This matter got infractions because it was challenging in 2022 combined completed examination. Examination of her appointment has been made. Moreover, this rule has been challenged for division bench and division bench also dismissed that matter. Yes. Had order dated 21/10/2022.
None appears for the petitioner on call. Mr. P.P. Dotto, Leonard Counsel representing the APSP. Petition. Yes,
My lord, it is covered by my lord, the division bench judgment.
Mr. Gupta appears for the writ petitioner. Counsel at the bar submits that the order passed by the division bench in writ appeal number,
Writ petition number 28/2021.
writ petition
28/2021
28/2021
and connected matter also.
and other connected writ petitions. Whereby division bench
Has dismissed in the challenge made in the rule of
dismissed the challenge made to the what rules?
also combined civil service 2020.
The combined civil services examination rules.
2000. I'm giving
Assam
the
Public Services
Assam Public Service Commission
Combined Competitive Examination Amendment Rule.
amendment rule also 2019.
2019. So the learned counsel for the petitioner therefore submits that nothing survives in the present writ petition. That the selection has already been made and appointments have also been made thereafter. Accordingly, writ petition stands dismissed.
I am for respond for one.
As in progress, interim orders, if any, stands vacated, pending IAs are also dismissed. Mr. P.P. Dotto for APSC
Respond what
and
5
Mr. T.C. Sutia for
One.
One.
obligation.
I wait for little accommodation on behalf of Mr. S. Holder. But otherwise, I think yes, government is supposed to produce the record of attendance.
Here, my lord, this contextual appointment that has been cancelled, my lord, immediately after 2 months. Then that has not been challenged. And secondly, my
So
lord,
you are representing whom?
I am for Hojai
Municipal.
Municipal Board. Man.
So there is an order earlier directing you to produce the attendance list.
That can be, my lord, but otherwise, my lord, if your lordship
There
kindly.
is an order. There is the judicial order.
is 2020.
21.
But otherwise, that's true, my lord. That part I can do, but otherwise also, my lord, since the petitioner has, their contractual appointment has been cancelled, nothing remains in the case. Unless and until it is challenged. And,
Mr. Teka, appearing upon on behalf of Mr. S. Porthabur, submits that the matter be deferred as Mr. Porthabur is not available. Report. He's not available.
He's in bereavement, his father expired.
He's in bereavement. Mr. B. Chetri, Learned Counsel, representing the respondent. Respondent number 2.
Yes, yes. That's what
Mr.
we have filed it.
Mr.
I have already filed it.
No, you are for 2.
Yes.
Respondent 2.
Yes, 2, my lord.
And Mr. Supriya for?
Yes.
You are for? Respondent 1. Urban Development.
This one.
Urban Development, Mr. Two. Let the matter be listed after 4 weeks.
Problem.
May it please your lordship. Matter relates to pay parity in the homeopathic medical college.
Pay parity in?
Pay parity of the faculty members of the homeopathic medical college, my lord.
Of the what?
Homeopathic medical college. And by order date 28th of August 2024, instruction was sought for any development is taking place or not. And health was getting, but finance was not getting instruction in short time.
Pleadings are complete here.
Pleadings are always complete.
Keep it for admission hearing. Matter be listed for admission hearing in the month of August on a date to be fixed by the registry.
May I pay for a date note 2015 matters?
Deborah, here for the Health Department.
Yes, Lord.
Ms. A. Porthabur for Finance. Is this matter on 5th of August?
Lordship.
5th.
5th month.
After 15th, Lordship.
August.
15th of August.
Why?
Lordship has fixed it on 5th of August. Lordship.
5th of August. Yes.
Obliged, Lordship.
Much.
Yes.
Yeah, please, your lordship. Your lordship, in this case, I have challenged.
Where is CGC?
This is here, your lordship.
The typing text.
Your lordship. From 35, it is changed to 20.
Yes, madam.
Malak, I have gone through the Supreme Court decision, my lord. In earlier occasion, they have submitted before the court. In that decision, my lord, in first page, my lord, there, may I read, my lord? Conclusion of the order, my lord. Kindly see the conclusion, page
This
Yeah,
is
42.
Tej Prakash.
It is, my
You are
lord.
referring to which?
Yes, Prakash, yes, my lord.
Yes. What are you referring to? Conclusion.
Paragraph 42, conclusion part, my lord. We therefore answer reference in the following terms. The recruitment process commences from the issuance of the advertisement calling for the application and end with the filling up of the vacancies. Eligible criteria for being placed in the select list notified at the commencement of the recruitment process cannot be sent midway through the recruitment process unless the extent rule so permit or advertisement which is not contrary to the extent rule so permit, even if such sense is permissible under the extent rule or the advertisement, the changes would have to meet the requirement of Article 14 of the Constitution of India and satisfy the test of non-arbitration. and 9, my lord. Then next is 42, clause 4, paragraph 4, my lord. Recruitment body subject to the extent rule may devise appropriate procedure for bringing the recruitment process to its logical end, provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary, and has a rational nexus to the object sought to the achieve. In our case, my lord, our rule permits, my lord, we have already filed our additional affidavit, my lord. That is page number
What about number 6?
Number 6, my lord. Placement in select list give in the indefeasible right for the appointment. The state or its instrumental for the bona fide region may choose not to fill up the vacancy. However, if the vacancy exists, the state or its instrumental can arbitrarily and deny the appointment to the person within the zone of consideration in the select list. But he is not come in the zone of consideration if that's as per my lord, clause 2, my lord. Because the rule permits us to sense that there and there is no.
You changed it after the commencement of the recruitment.
Yes, my lord.
Then how
Then
does
kindly
clause
see,
2 apply?
well, that is clause 2, my lord.
No, see clause 2, read again.
Eligibility criteria for being placed in the select list notified at the commencement of the recruitment process cannot be sent midway through the recruitment process unless, kindly say the next line, my lord, unless the extant rules so permit or advertisement which is not contrary to the extant rule so permit. Even if sense is permissible under the extant rule or the advertisement, the sense would have to meet the requirement of Article 14, my lord.
So where is the rule?
Rule is in my our additional affidavit we have filed. That is page number 117, my lord.
117.
And relevant portion in page number 1187.
Yes.
Next page, kindly say, my lord, 7, clause 7, my lord. That is written in the skill test and norms on computer.
Clause 7.
Clause 7, my lord. In page 118, my lord, 7.
Yes, yes.
Yes. Intermediate of senior secondary school certificate examination and skill test, my lord. English type minimum speed 35 on the computer. Hindi typing minimum speed 30 30 WPM on the computer. That is an 35 W in English and 35 Hindi corresponding to 1050 kdph in English, in Hindi. My lord, these are the rules which can be sensed. Then physical standard says, my lord, this rule can be sensed as per the my lord.
Where is that permission? Where is the provision of the rule that you can change it?
My lord, that is kindly see, my lord, page 117.
117. Yes.
8, my lord, power to relax, my lord. When the central opinion that it is necessary to expend the resource to do it, it
You
may.
relax it, but it does not. How do you say it implies that you can relax it?
Yes, my lord.
Anytime you want?
Yes.
You relax it at the time of advertisement.
But that
You
is
relax
as.
it. You see, nobody has asked you to go for advertisement.
Yes, my lord.
You go and pick up people from the street. Who's questioning it? You have chosen to give an advertisement.
Yes, my lord.
You have chosen to lay down standards. You have chosen to invite application. You have chosen to lay down the process or the criteria for selection.
Yes.
Once it is that, once you know that these are the candidates with these kind of achievement or underachievement, midway you change the rule. You bring down the scale. How is that permissible? How can you say that this is permissible under Rule 8?
But all rules are all criteria is not permissible. Only these, by the physical standard, skill test, these are permissible under the says, my lord. That is only permissible under the rule, my lord.
Where does it specify that skill test is permissible?
My lord, kindly see, this is
The power to relax rules is there in every authority. But you must notify it.
a notifying there, my lord.
Where?
In the
See, it goes like this. Your criteria was how much? 35.
30.
Yes.
Yes.
You have brought down to 25.
20.
20.
Yes, my lord.
Now, how many candidates are there?
In 35, only 13 candidates are there.
13 candidates.
Yes.
Now, there may be some other candidates elsewhere who had 25 or
Yes, ma'am.
20 who could have applied, but they know that their speed is not 35. So they did not apply. But if they had come to know that their criteria, they would have satisfied the criteria, had they applied, they could have applied.
After my lord sending the criteria, my lord, that
You
had-
can do that. That is extension beyond the reasonable limit permissible.
yes, ma'am, that is one of-
Otherwise, what is the point in having a rule? We can
because-
change it anytime, anywhere, any criteria. You have a set of rules.
Well,
These rules are, you have accepted these rules.
yes, ma'am.
You have the power to relax. Now, whatever relaxation you must have, you must show this relaxation at the time when the advertisement is there or before the commencement of the recruitment process.
Yes, ma'am, but as per these judgments, my lord, says Prakash, my lord, that clause 2, my lord, they permit, my lord, in certain circumstances, my lord. And that should be transparent. That is transparent in our record also, my lord. There is no arbitrariness in by sending the criteria, my lord. There is no violation of Article 14. That is applicable for all over the India, not for certain specific categories, certain specific region. There is no.
What are the facts here?
Next.
May I please, Your Lordship? Your Lordship, the advertisement is, it is 14, Your Lordship. It was a selection of Havaldar clerk in some record, Your Lordship. And for that, Your Lordship, this is the advertisement is 14, Your Lordship.
No, I'm referring to the judgment that we have taken.
This judge. Technical context. So it's 2%. My lord, that is in paragraph 2, my lord, page
1 and
3.
2.
That is Rajasthan High Court.
Page 4, Your Lordships.
Yeah, read it. What are the facts? Tell.
Your Lordship, the relevant facts give rise to the following references as follows, Your Lordship. The Rajasthan High Courts, the High Court by notification dated 17 September 2009 invited application from among the judicial assistants and junior judicial assistant having the experience of 3 years in the establishment of the sorry, Your Lordship. So, Your Lordship, having the experience in the 3 years in the establishment of the High Court and passing of the degree of MA in English literature for appointment of the 13th of the translator. Reference was to be accorded to law graduate. At the relevant time, the Rajasthan High Court Staff Service Rules 2002, rules of 2002 rules framed by the Chief Justice of High Courts under the Article 229 of 2 of the Constitution of
You tell
India.
us why are you reading it word by word? We want to know what are the facts involved in this case and how is it relevant for you?
Your Lordship, in this case, also Your Lordship, that your Lordships, in particular, Your Lordships, page 6, Your Lordships. Your Lordships, the minimum percentage for Your Lordships selection is 75. And it was brought down to Your Lordship 50. In mid of the selection, Your Lordship. 75%. ठीक है जी ना
You are reading it now. You read it and come back after reading it. Then. With the relevant case law support of the list after making.
Hello.
Yes.
This is now the opposite party has to produce the record. 11-6 tell the order of from the court. 11-6.
11-6.
11-6 already.
Yes, Mr. Nayak, who's there? Yes, Mr. Goswami, Mr. Borpuzari, what record?
On behalf of finance, we have already filed the affidavit.
So some records were directly to be produced. What record?
Yes, my lord, the
Lordship.
college will
Yes, yes,
be
Lord.
producing the
Yeah,
record.
Lordship.
So the administrative department here is, my lord, the Department of Municipal Administration.
Lordship, can you see our affidavit, Lordship? Additional affidavit, page number 137, Lordship. Running page number 137.
My lordship. Lordship, there is a specific order for producing the record. Earlier occasion also, there is order 4-4-24, lordship, 5-25. So all the time they have diverted the issue. Issue is not this thing. So affidavit is not served the purpose because they have diverted it, twisted the matter to some other. Lordship kindly 4-4-24 order, lordship. 4-4-24.
Yes, 4-4-24, Lordship. Here, Lordship, it is directed that the specific instruction on based on the record on as regard the aforesaid issues, whether the 55 numbers of the petitioner would come within the 5,170 numbers of posts identified and recorded in the cabinet memorandum dated 4/09/2013. This is the direction, Lordship. And as per that direction, Lordship, we filed the affidavit, Lordship.
No,
Specifically stated.
5-2, there is another order, 5-25.
No, was there a cabinet decision?
Yes, Lord.
Where is that?
That is, I have annexed in my read petition.
Page number?
Yes, 100, Lord. If I am not wrong. Yes, Lord. Page 100 in my read petition.
Where is that? Where is the records pertaining to this document, page 100?
Lordship, in my reply 137, Lordship, it is categorically stated that this cabinet decision was taken on principle, Lordship. It is on
What is the
principle.
meaning of that?
Yes, Lordship. approval was given to the provincialization of 5,170 posts for 5 categories of ULBS. Now, Lordship, after that, it was reviewed, Lordship. It was on that the Assam Municipal Employees Act 2021 was enacted 31st May 2021. Originally, 1653 numbers of employees who were found to be the employee post on regular sanction post of ULBS appointed prior to 4th September 2013 were proposed to be converted under the ambit of the Act. The Honorable Cabinet on 10 January 2025 instructed the Department of Municipal Administration Assam to prepare a draft bill in consultation with the School Education Department and also for repealing the Assam Municipal Act 2021. As it is post some illegal implement. In the line of the above, the Honorable Cabinet on 5 February 2025 given approval to the Assam Municipal Employees Provincialization Bill 2025. Now it is, which seek to be provincialized the service of 1,044 employees presently service regular employees post in 71 UBS appointed on or before 4th September 2013 under general areas and repeal the Assam Municipal Act 2021. The Assam Municipal Employees Provincialization Bill 2025 was tabled and passed in the Assam Legislative Assembly on 6th March 2025. But this bill is yet to be notified. However, the petitioners were not included in the 1,044 employees under the Assam Employees Provincialization Bill 2025. It is clear. The cabinet was gone. That cabinet decision was reviewed, Lords.
Where is that order?
This
page number? Where is the order of review?
This Lordship, the new Act 21 after enactment of 21 Act, Lordship.
The page number 100.
Yes.
There is a decision by the cabinet.
Yes, Lordship.
In principle.
Oh, yes.
Now, for this decision to be reviewed, there must be a specific order that or specific decision that the earlier cabinet decision stands reviewed in view of enactment of the new act or modification of the new act, etc. There has to be a process. By implication, you
No, that was not processed. That decision of the cabinet in 2013 decision that was not under process, Lords.
It was not processed. That you have to answer why you have not processed the decision of the cabinet. How the government can stall a decision of the cabinet? It's at the highest level of the administration. Decision of the cabinet cannot be tossed around.
That was not implemented, Lordship.
It was not implemented, then the question is why is it not implemented?
Now, Lordship, the new act came.
New act comes later, but this decision remains. Governments may change. The parties may change, but the government has to be there. It's a decision taken by the cabinet. What steps have you taken? By implication, you cannot override a cabinet. Who has given the authority to the officers to override a cabinet? They may refer it back to the cabinet for reconsideration. They have not been empowered to take decisions on behalf of the cabinet. So therefore, the record.
Lordship. Now the record, Lordship. regarding the record of this cabinet decision, Lordship.
See, there is a extract of a cabinet decision and
Yes,
to
the-
the writ petition and page number 100. You have to respond by saying in three modes that this is not a correct reflection. Or this decision, although taken, was reviewed. Or this decision remains not.
Decision, cabinet decision, Lordship, after that, this act, when the new act 2021 came, Lordship, the earlier, Lordship,
It is whose decision or interpretation? But he has to take a decision
Lord,
that this earlier cabinet decision in view of subsequent amendment is not required to be implemented.
on that point, Lordship, I have to take instruction.
It is because the instructions are not forthcoming, perhaps the court directed, let the record be there so that we
The
can
record, Lordship,
apprise ourselves. What is the status?
no, state, Lordship, this, no list was prepared, Lordship, regarding the,
We don't know. Either you say that this cabinet decision is not a decision in effect because of,
on principle, it was taken.
so what is the meaning of on principle?
Lordship, before
What is the
taking,
meaning of on principle?
yes, before taking this decision, Lordship, no list was prepared, Lordship.
Then somebody has to take a decision on this. Either it has to be referred back to the cabinet again to say that, no, this decision is not as per the proper.
And no action was taken on this decision, Lordship.
Lordship, finally, Lordship, for page 103 of my petition, that Finance Department has already approved. Approval is there. Cabinet decision, approval 103, my page, writ petition. Approved by the Finance Department. Thereafter, they are not producing the record. They are diverting the issue from this and they 19 case, Lordship. Initially, they filed 2 affidavits, it is contradictory. Then when we produce this approval order, then they have diverted the issue one by one. So it is from 19 to 25, all the retired employees. And the cabinet decision 25, whether they can take the retrospective effect. It is 13 decision, cabinet decision. It is approved in 13, not implemented till today. Finance Department has approved. Approval order is page 103. Let them produce the record. Why they are
Why are
hesitating?
you shying away from production
No,
of the record?
Lordship, I do admit it, but record means which record, Lordship?
Cabinet decision with the
No,
list.
yes, no list was prepared. It is categorically stated. Before taking the decision of the cabinet 2013,
Where have you stated all that? Where have you
Lordship,
stated?
If I may submit, my lord, page,
We are not done with him. We'll come.
my
to
lord,
you.
my lord.
yes,
Yes.
Lordship, this is categorically stated the decision was
Page
taken.
number, page.
Yes, 137, Lordship.
137.
137 in my affidavit, Lordship.
Yes.
I categorically stated said that however, the cabinet decision was taken on 4th September 2013, wherein in principle the approval was given for provincialization of 5,170 posts for 5 categories of ULBS. It means, Lordship, factually it was not taken, Lordship. On principle it was taken. No list was prepared, Lordship, before taking that cabinet decision, Lordship.
Now you come to the affidavit sworn at page 138.
Yes.
He is the director,
Yes,
municipal administration.
Lordship.
These statements are made in para 2 of
Yes.
your affidavit.
Yes, para 2.
Now see how the affidavit has been sworn. Para 6.
It is on record, Lordship.
Para 2.
Para 2. 130
Para,
page
para 6, page 138.
138, para 6.
Hmm.
that the statement made in paragraphs 2 of the of this affidavit, it means affidavit are true to my knowledge, those which made.
Knowledge.
Yes. Lordship.
These are true to his knowledge.
Lordship.
We don't want his knowledge. We want the position and the records. His affidavit you are relying on are on the basis of his knowledge. From where he has got the knowledge, we don't know. Whether it is
No,
to the records.
Lordship, those made in paragraphs 2 are true to my information delivered from the records. It is categorically stated in the next part.
You get the records from where he has obtained his
Lordship.
information.
Lordship.
Yes, Mr. Borpujari, anything you wanted to submit?
Yes, my lord. Page 103 has been drawn attention to, my lord. 103 of the writ petition. The petitioner contends that this is an approval of the finance department. This is not an approval of the finance department. It is only a mere communication, inter-department communication. Page 103. I have to make it clear, my lord, because my affidavit says otherwise. Page 103, Lordship is taking up. Kindly see, my lord. It is only a letter, my lord, from the finance department to the Panchayat and Rural Development Department, Urban Development Department, Guwahati Development Department, informing them about, my lord, this cabinet decision. Only that extent.
And for taking necessary action?
For necessary action, it is up to them, my lord.
What necessary action?
So necessary action, whether, my lord, on principle, how it is to be followed, my lord. It is only a mere communication, my lord. That line may be there, my lord, to take necessary action. But where is the approval?
You produce the records pertaining to, along with the cabinet memorandum in respect of this decision which was taken by the cabinet.
No, 2013, the cabinet decision was taken, Lordship.
We want the cabinet memorandum.
Right. But that was
placed before the cabinet.
That was not, after that was not.
We want to see what was placed. That's all. But counsel for the parties. Time and again, orders have been passed to the court, directing the respondents to produce the relevant reports. The petitioners are aggrieved that in spite of a cabinet decision taken on 4th of September 2013 to provincialize within forts in principle, forts closed, 5170 posts for 5 categories of ULBs. What is ULB?
Urban local bodies.
Urban local bodies, ULB, including regular pay, scale of pay for sweepers, along with the corresponding scale of pay recommended by the port ASFC. Stop, the consequential steps required to be taken by the government to implement the cabinet decision was not taken. So petitioners have in the meantime superannuated from the service, and since the cabinet memorandum was not given effect to, the pension has not been considered in respect of the writ petitioner. So in this context, this court on earlier occasions directed the respondent authorities to produce the relevant reports. So today, when the matter was today in the matter was called up as a fixed item, counsel for the respondent, Mr. K.K. Goswami, submits that the records are not available. Rather, he has referred to the affidavit filed on behalf of the department to submit that the cabinet decision on 4th of September 2013 was essentially a decision in principle within courts, which was subsequently not followed up by the government. Stop. Subsequently, which act was brought in?
Now it is, Lordship, The Assam Municipal Employees Provincialization Bill 2025.
Assam Municipal
Employees Provincialization Bill
Employees Provincialization Bill
2025.
2025
Provincialization within
For-
bracket.
for provincializing how many posts?
Lordship, it is 1044.
1044 posts. He is under consideration, however, before the cabinet. However, as on date, the said bill has not been passed. Stop. It is submitted that in view of the bill being placed before the cabinet, if the cabinet approves, the follow-up, the necessary follow-up action will be taken by the department. So, be that as it may, this court is of the view that since the earlier orders have been passed, orders have been passed on earlier occasions, directing the respondent to court. This court reiterates the earlier direction to the respondent authority. Which authority will produce?
Commissioner Secretary
Of
Urban. The Commissioner Secretary, Assam Municipal Administration Department.
the respondent number 1.
Yes,
the
Lord.
Commissioner and Secretary, Government of Assam Municipal Administration Department to produce the relevant reports leading to the cabinet decision dated 4th of September 2013. Stop. Let the reports be produced. Again on, let the report be positively produced to the board. Yes, give us your dates.
Record in the cabinet memorandum.
Whatever records are there relevant, leading to the cabinet decision. When can you produce it? Tell us.
Lordship, after vacation, Lordship.
We produce on 23rd of July. Failure to produce the records may invite consequent election. Orders from this court. This recording. Mr. Arbor Pujari for the finance department. Yes.
She has come with some.
This matter is pending for service.
Lordship,
Why did you provide the
Lordship, at that time, 22nd Battalion was at Sonapur, and at present, 22nd Battalion is posted at Maharajganj, UP. And neither the commandant of that battalion is a party. And this petitioner, Lordship, had went on voluntary retirement from 1/1/2018.
bill here on there? In so far as respondent 4, where is he posted now?
No, he voluntary retirement.
Retired.
Yes, 1/1/2018. And battalion is in UP. So difficulty to obtain his correct address.
He's
2018,
already taken voluntary retirement.
yes. That instruction I have, I can provide.
Well, if it is voluntary retirement, he gone, then definitely his address, permanent address will be there, my lord.
No, what are you claiming now?
My claiming is that as per his pilot date of promotion, I should be considered
In
because
his
I
place,
was,
in
I was
his
saying-
place.
Yeah, not on his place. I am not disturbing him. I am, my lord, saying that there was a, my lord, the departmental promotion committee, that
Then you
was I was in consideration, but my case was not considered in
But
spite of
then-
my seniority.
Then you have no claim against him.
I have no claim, but
Then
as
why
per
did you
his
get it
date
with
of,
the party?
as per, because my lord, he was my junior, that is why I made him party. I said, my petition was that I should be promoted as per his date of promotion. That is that enough.
Third, is as per instructions received by the Learned Standing Council, Learned CDC MSB Sharma, respondent 4 was subsequently posted in what, 22nd Battalion?
He was in 22nd Battalion and he retired
2nd Battalion, which is presently stationed in the state of UP.
UP.
So, however, the respondent 4 opted for voluntary retirement, which was
with effect from 1/1/2018.
approved with effect from 1/1/2018. So, as on date, the petitioner, respondent 4 is no longer in service and is in retirement after his application for voluntary retirement was stood approved. So, there are, from the grievance of the writ petitioner is his claim of promotion with effect from the date his junior, the respondent number 4, stood promoted. So, in the prayers in the writ petition, there is no specific relief sought for against the respondent number 4. Under such circumstances, this court is of the view that respondent 4 is not a necessary party. Accordingly, registry will, accordingly, it's directed that respondent 4 be struck off the array of parties. Petitioner will file amended course title to their effect. Matter be listed.
Otherwise, well, pleadings is completed, my lord.
Thereafter, since the pleadings are complete, matter be listed for hearing.
After my lord, vacation, my lord.
Course after vacation.
Must.
Okay.
The date to be fixed by the date.
Well, in this matter, I am on behalf of the senior government advocate D Nat. I am told that SLP has been filed in the Supreme Court, my lord. So matter may be taken up after vacation, my lord.
When was it filed?
That was he told me when, I don't know, my lord.
Where is Mr. Nar?
Not that he is under court, my lord. He told me.
We had deferred the matter on the ground that he was not available.
Well,
He's still not available.
He told me that, my lord, the SLP has been filed. That has been filed.
But you don't have the number and the date.
I don't know the date, my lord. That was, he did not tell me.
Mr. Kotoki, as Kotoki, learned counsel appears for the petitioner. Mr. T.C. Sutial, an additional senior government advocate, submits that he has been informed by the senior government advocate that an SLP has been filed against the judgment and order dated.
Against the judgment and order in writ appeal, my lord, 18/2/25, my lord.
18/2/2025, passed in writ appeal number
398/23.
398/23. So, in that view of the matter, this court is of the view that since the SLP has already been filed, the particulars of which have not yet been furnished by the government advocate, matter stands deferred, to be listed after 2 weeks. The respondents will apprise the court regarding the status of the SLP. Stated to have been filed. Placed after 2 weeks. Yes, Mr. Mozumdar, what is the matter about?
This is regarding appointment of additional notary. Last time, I'm told last time also, my learned friend appearing for the petitioner didn't appear.
And appears for the petitioner on call. Mr. T. Mozumdar, additional AG, Assam, represents the state. TP.pro for
8, 9, and 10, okay, respond number 8, 9, and 10.
respondents 8, 9, and 10. Mr.
Yes, sir, yeah.
Let's say Bhatia appears to respond by 11. MS D Das for 7. Let the matter be called up immediately after vacation on a date free. respondents in the meantime may complete their pleading.
Lordship may have a look at page 38. That is the groundwork challenge.
30?
38.
38.
Page 38.
And it should be read in a lighter vein, my lord.
38.
Anyway, after a few serious cases, one such case is necessary. After a few serious cases, one such case is necessary.
I am the privileged counsel of that petitioner respondent.
Anyway.
Implement, any objections?
It can be allowed, my lord. Implement.
But although none appears for the, who is appearing? Mr. Borua, he is mentioned in the morning.
Yes, ma'am.
What does he?
30.
My lord,
Yes.
my lord, that IA was not my lord here received. I have called for the.
IA is available, council is not available.
Oh, my lord, sorry.
Yes.
My lord, here UDD was the authority, the department who regularized, my lord. Now, their presence is required. Now, UDD become housing and urban affairs, my lord. So I need them
Any
to.
objections from the respondents?
No objection, it can be allowed.
Mr. N.J. Pawar, I counsel to the applicant as well as the writ petition of the application number 3157 of 2022. The IA has been filed seeking implement of what?
Department of Housing and Urban.
Department of Housing and Urban Affairs.
Yes, yes, please.
Stop the petitioner has prayed for regularization of his service in the writ petition, the accompanying writ petition. Stop. The regularization of the petitioner was in the what Assam Urban Water Supply and Sewerage Board.
Yes, but page 33 says that UDD has regularized their service, so they have to be present. Now UDD become this housing.
The is the claim of the petitioner that the Department of the Urban Development Department
Yes.
of Assam had regularized the service as of the petitioner. UDD was
Now
as a
become
party earlier.
not now it become a lot this housing. That is right.
Stop. The Urban Development Department subsequently has been re-nomenclatured as Department of
Housing and Urban Affairs.
Housing and Urban Development. So, since the question of regularization of the petitioner since the petitioner has sought for a direction to the competent authorities in the department in view of the claim made by the petitioner that his regularization in effect was granted by the Department of Urban Development, Department of Assam. The state department is required to be added as a party, which has now been re-nomenclatured as the Department of Housing and Urban Development. Stop. Therefore, the IA has been filed seeking the Department of Housing and Urban Development as party respondent number 7 in the accompanying para. The respondents represented by Mr. Rai Bodhapur for PHE, then
Ms. B. Devi Lordship on behalf of Mr. S.P. Chaudhary for respondent number 4.
Ms. B. Devi appearing for respondent 4, and Ms. A. Bodhapur for finance.
Lordship.
Do not object to the prayer made. Stop. As such, without issuance of notice at this stage, the IA stands allowed. The Department of Housing and Urban Development is the rate as party respondent 7 is the accompanying writ petition being WPP number 3157 of 2022. The petitioner will file amended post title within 2 weeks. IA accordingly stands allowed disposed of in the writ petition, right, in view of the order passed today, that is 24/6/2025 in IA number so and so. Department of Housing and Urban Development is the rate as party respondent number 7 or 6. 6. So petitioner is directed to file amended post title within 2 weeks from today. Let notice issued on the newly implemented respondent, the Department of Housing and Urban Development. Who accepts notice? Mr. Sutia, Housing Development.
Urban Development my lord,
Mr. Bora. S. Bora.
P Nayak my lord, there P Nayak.
Mr. P. Nayak. Yes, Mr. Nayak, you are invited. Yes, Mr. P. Nayak, additional AD appears and accepts notice on behalf of respondent number. Newly implemented respondent number 5. 6. Therefore, notices are waived. However, extra copies be furnished within a period of 1 week from today. The respondents, including the newly implemented respondents, may file their counter, if so advised in the meantime. Test the matter for admission in the month of August on a date to be fixed by the district.
Obligation.
May I please interrupt? And a recruitment process was conducted by the respondent authority. I was one of the candidates for the post of medical assistant grade 4 pathology. The advertisement was published in the month of January 2019. And the first stage, that is the computer CBT, computer-based test was conducted, and my name was placed in the selection list on the basis of the CBT. Thereafter, we were asked to upload our documents. The second process is second and final process for uploading the documents and the application test. That is,
your case has been rejected.
No, Lordship.
Not rejected.
Not rejected.
The recruitment process itself was scrapped.
Crap.
Not
As a matter
candidates.
a policy decision was.
Some candidates were given appointment and a cancellation notice was published in page number 38.
What is your prayer here?
My prayer is that the recruitment process may be conducted.
Is there policy decision?
Lordship, it is arbitrary. Some candidates were given appointment.
Who are these candidates?
Other candidates, numbers of candidates.
Have you added them as parties?
Lordship,
Have you made them parties?
other no candidates.
Yes.
Ours, 11 total, 11 numbers of this.
All right, there are 11 numbers of posts. You
30,
apply
30 numbers of
for 30 numbers.
11
of posts,
discipline.
30 numbers of posts. They decide to appoint somebody, don't appoint somebody. You are claiming appointment.
not appointment, to complete the recruitment process as per norm.
For what purpose?
Because in the midway,
No. Why are you asking for completion of the recruitment process?
Because
So
it-
that
it
you
is-
may be selected
yes,
and
yes,
appointed.
finally, if I will, that is the ultimate goal, but initial goal is to complete the recruitment process.
So the recruitment process, as far as you are concerned, is not for a pleasure, isn't it? It is to be completed so that you may offer your candidature, selected and then appointed.
Yes,
According to you, they have not proceeded.
proceeded.
But some other persons have been appointed.
Other category, in other post,
So you have to
not our discipline,
how many petitioners are there?
only, I am only petition.
Only petition.
Yes.
So you have to challenge somebody's appointment to say that that person's appointment is not correct.
Lordship, Honorable Gujarat High Court, at the same time, the same advertisement was published in all over India. Honorable Gujarat High Court, also, here is the page number 39, Lordship.
No. If there is a policy decision taken,
Yes,
unless you show that this policy decision is bad, arbitrary,
yes, arbitrary.
why is it arbitrary?
Because they have taken the plea that due to COVID-19, their financial condition was bad. Their posts were appointed.
You are not putting them to challenge. You have to challenge this post that my appointment process has been stalled. Somebody else has been appointed. Some doctors.
No, other posts, there are number of posts. Only paramedical posts were keeping hold, cancelled.
What about what other posts?
Other posts got appointed.
Yes. Why have you kept out the paramedics?
Your lordship is aware, ONGC is mainly into oil exploration and all that. So there are several categories. If your lordship will kindly come to the advertisement at page 12. Page 13 onwards, your lordship will find these are all technical posts. And at page 15, serial number 33 to 41, these are paramedical posts which were advertised. So on account of COVID-19 at that point of time, for the other technical posts which are required, which are inevitable for our functioning, we carried on. And for these paramedical posts, we felt that we will not proceed. So that's exactly what we have stated in our affidavit. That as a matter of policy, we took this decision on account of various financial implications. And that is how it has been scrapped. And these are non-core activities. And there is, in fact, my lord, if your lordship will just make a note of the dates, we cancel, the advertisement is of January. We cancelled it on 21st of January 2022. He files the writ petition on 2/2/24. The reason is very simple. In the meantime, in case of a similar advertisement, Gujarat High Court passed an order. So he founds his cause of action on the basis of the Gujarat High Court judgment, which also subsequently has been stayed by the Supreme Court.
It was a fight between the union. It was at the instance that court ordered a fight.
And in Gujarat High Court, the whole issue was at the instance of the union. Some contractual employees, etc. Here that is not the case. Here is a individual candidate, and that too, the selection comprised of 2-3 different stages. It was immediately after the first stage itself we decided to scrap. We have made our position clear in para 7 of the affidavit.
It was there at the first instance, the decision to keep the recruitment on hold had been taken upon the representative, which is very correct. Good.
Para 6 and 7.
Matter is pending before the Supreme Court.
Yes. And there is a stay.
Where is that order?
That we have made a statement.
Can you place the order?
Page 30. Go to, sir. You can go to. And in fact, Tripura High Court has also dismissed similar petitions.
Yes, it is state. Judgment is state.
And even that was enough. The context was different. There, the delay cause was on account of pressure put by the union. Therefore, the Gujarat High Court interfered. Here, it's a pure pilot decision. In fact, if your lordship sees the dates, in November 2019, the computer-based test results were published. Immediately thereafter, COVID hit,
Let
and
us
thereafter
await-
we took the
Let us
decision.
await the outcome of the apex court, since the matter is pending.
Otherwise, even the law is otherwise quite settled.
Then we'll
That
accept. Yes.
there is
Lordship,
even selection does not confer any right.
in the cancellation notice, no reason has been cited. Why is your cancel? Even we are not in.
You are relying on a Gujarat High Court judgment.
Yes,
It is
sir.
state. What do you have to say regarding that?
Our case may be decided on merit.
On merit, not. All right. Do you want a dismissal today or on reopening?
Sometimes we may be given to come out the decision. No, no.
Otherwise, the grounds that you have urged here don't confer you any right. It's a policy decision they have taken. Unless you say that you are challenging somebody's appointment to say that you have been given an unfair treatment. And the Gujarat High Court, it appears there were several writ petitions filed and some directions were required to be complied with. Initially, some of the petitioners were rejected on the ground of, I think, domicile. Domicile, not possessing domicile certificates. So your case is a pure case of the policy not being taken by the authorities to go ahead. What is your right?
Different issues are involved in this case.
What is your right?
My right is this decision is quietly arbitrary.
That is your submission. What is your right? You are demanding a writ. What is your right? What is your legal right? That a direction should be issued to continue with the selection. You have to establish your right. Dismiss it.
Till the decision of the Honorable Supreme Court. Till the decision of the Honorable.
But we asked, you said you want the matter to be heard. Matter stands deferred to be listed after 8 weeks in view of the fact that the judgment of the Honorable Gujarat High Court, which is referred to and relied upon by the petitioner, has in the meantime been stayed in a bunch of special leave petitions filed before the apex court. Copy of the order dated 5th of August 2024 is placed to the court by the respondents. This after 6 weeks. Mr. Rai Chaudhary and senior counsel assisted by Mr. S. Chakraborty.
At times we get confused between S and K.
Right.
My lord, I'm praying for timing up of this matter. My lord, arguing counsel K. Ansudil sir is less in another court. My lord.
My lord, in this matter, my lord, M. Bhattacharya is dealing with the matter. She has not come today. My lord, lordship heart and leg.
Matter stands
Matter-
referred to be This is nomination into IS.
No, this is suspension, Mondal. He's already retired.
Joint prayer, the matter stands deferred to be listed after 4 weeks.
After vacation on 17, 18, my lord, July.
17, 18.
17 or 18.
After 7.
18, my lord. 18 July.
18 July. Okay.
Much obliged.
My lord, in this case, the consent and declaration are sought for from the proposed article.
You got it?
Maybe on the record.
In fact, Lordship, I tried to look, Lordship's last order is not uploaded.
There was a problem. The order was not typed out or dictated in time, but came to our notice, we requested the registry to list it. Be available. Is it available on record?
Maybe
It's not available on record.
not available.
Do you have a copy?
No, I don't have. It was, the earlier order was not uploaded, so we cannot take it. Step.
What was the direction earlier? We'll do one thing. We'll keep it on Thursday.
Yes.
We'll pass orders again because this order is not available here. What was the direction issued?
Direction issued for the,
Was made.
So that needs to be communicated.
yes, yes. Name was suggested, my lord.
Name matter be listed on Thursday. Thursday we'll pass orders.
My lord, I may not be available on Thursday.
All right. Then immediately after vacation,
On 14th?
Yes, yes.
14.
14th?
14. 14 July. Is this matter again on 14 July?
Right.
Yeah, let's see, I am editing instruction note.
That's a matter for in family pension. Here, Lordship, pension paper already prepared by the district authority, and that has been given to the petitioner. Already, I have returned back to that office, concerned office. So, see, if the pension paper already ready, no, matter may be disposed of.
Lordship, it is under process, Lordship. So, Lordship, fix after vacation, Lordship, we can have the instruction, Lordship.
One thing, my lord, only I am for the respondent 9, 10, and 11, lordship. My learned friend, my lord, petitioner is submitting my lord pension papers is there, my lord, pending lordship. Maybe disposed of my lord, in terms of the much.
Not like that.
Oh,
We are fixing it on 14th.
15th, Lordship.
Huh?
15th.
15 July.
Lordship.
List the matter on 15 July by which date the Standing Council irrigation.
Lordship, 1678.
16, 7 and 8 will apprise the court of the status of the process steps taken on the pension proposal of the
Yes, Lord.
of the husband of the writ petition.
No, Lord.
Husband.
Wife of the
Why would the already?
You are asking for pension of the husband.
Yes.
Yes, Lord, sorry.
Husband of the writ petition.
Lord.
List on 15th.
All right.
Mr. So-and-so appears for the response. Yes. You are under suspension.
Yes, ma'am.
The records were taken.
Yes, this is the record. Lord.
So what do you want to show from the record?
No, I have not yet gone complete record. I have not gone through. But Lordship, the last extension, Lordship, it was on 21/3/2025, wherein the reason for extension was that in view of above, considering the gravity of the alleged offences, as well as charges framed by the investigation officer, Chief Minister Special Vigilance Cell, Government of Assam ensures sit file in ongoing criminal case, Vigilance PS number so and so. The suspension period of Sri Hiranya Burman, Executive Engineer, code number so and so Guwahati, is further extended until further order. So this is the latest extension, Lordship. It was in the month of March 2025. And in the record, Lordship, I can only show the search sheet wherefrom Lordship may ascertain the gravity of the offences, Lordship.
No. Let us see the rules. What are the charges, Prem?
Yes. DP has been initiated, and in the criminal case also search sheet has been filed, Lord.
No, DP initiated, has it been, what is the status of the DP?
It is going on, Lordship. Going on, Lordship, although initially some difficulties were there because of want of files, Lordship. Now, Lordship, some records we have gathered, Lordship. And thereafter, Lordship, lastly, Lordship, if Lordship goes through my affidavit, Lordship will find there. The IO has also been appointed, Lordship. I mean, lastly, page 209. So there, it has again been started, Lordship, and IOPO has also been appointed.
What do you say with regard to the judgments of Rigen Haloi and Ojit Sonwal?
Lordship, Ojit Sonwal on a different, Lordship, for as our case is concerned, the present case is concerned, Lordship. Ajay Kumar Chaudhary no longer applies, Lordship, because already a coordinate bench has granted us the liberty to review the suspension of the petitioner. That was subsequent to expiry of 90 days, Lordship. So that issue is over. Lordship has seen the judgment passed by the coordinate bench, Lord. Here in the world. Petition. Page 72. Page 72, this was the earlier writ petition, Lordship. If Lordship comes to page 74, paragraph 7.
So you are challenging this on the ground that this is not a reason.
Yes, ma'am.
And my submission will be, Lordship, whether gravity of the offences is a sufficient ground or not for continuous suspension. That will be my submission. And I will place a few judgments on that point.
No, so-called notice was issued, my lord. Subsequently, my lord, supplementary so-called notice was issued, my lord, on 24/8/2023.
But what is the stage of the departmental proceeding?
My lord, when I submitted my application for inspection of documents, my lord, they have expressed their inability that no.
It was earlier, Lord.
Yes, my lord, it is.
What is the current status?
In our
What was the
additional,
last date?
yes, my lord.
Yes, they are saying that the instruction of the last instruction. Lordship, one letter dated 16/6/2025, probably in the file, Lord. On last date, I furnished. 16/6/2025.
Yes. You're asking for seized files and documents.
Yes, Lord.
So this is not a case that the departmental proceeding has commenced.
Yes, no, it has commenced, Lordship. Lordship has seen 21/3/2025, page 209. It was earlier, Lordship, appointment of IO and
No,
PO.
it has commenced.
Yes,
Commencement will be from the date you issue the charge sheet, the show cause notice.
yes,
So it has commenced.
yes.
So what is the stage? At what stage is the proceedings now?
That is difficult to say because
Then?
after appointment of IOPO,
Why is it difficult to say? It is within the department.
but
only.
because of this instruction, Lordship,
Which
this is
instruction?
16/6.
16/6.
It was on the basis of an order, specific order passed by your Lordship.
Relevant files are still in the custody.
Yes,
So therefore, effectively, it has not progressed.
but whether that can be a sufficient reason for interfering with the suspension order or not, Lord.
That depends on what is the ground for keeping him under suspension.
Yes, that ground is the gravity of the offenses.
What are the
That is the last section, and that is why I placed the record, Lordship. There, the search sheet is, or copy of the search sheet is also there, Lordship.
There has to be a finding in the order that where is the order you are challenging?
15/6/2023, man.
15/3.
2020. Page number 81, madam.
You can tell me that?
Is 81.
15/3.
Yes.
15/6.
Yes, 15/6/2023.
But you see, if you go to rule 6.2 of the rules, there is a proviso that where the detention is not on account of a charge connected with his position or something like that, is likely to embarrass the government, it does not involve moral turpitude, the appointment authority may vacate.
But here the situation is different. It relates to.
Where is the finding? On page number 81.
No, what allegations pertains to.
Where is the finding? Page number 81.
No, that was the one first extension law. So subsequently also extension orders were there. Two copies just now I have furnished, Lord. So this 21/3/2025.
Hmm. 21/3.
Yes, 21/3. This is the last extension, Lord. If Lordship comes to the paragraph number 3, in view of above. In view of above, considering the gravity of the alleged offense, as well as charges framed by the investigator.
Prima facie, it appears that your charges, the disciplinary proceeding, and the criminal charges in the criminal proceedings are one and the same. Then also you're barred.
No, in that case, Lordship will keep the DP in abeyance.
Where is the necessity to keep him under suspension?
That is what I'm trying to submit, Lordship. Now, whether just because the DP is getting delayed, that alone be a sufficient ground for interfering with the suspension order or not. That will be my point of argument.
You have to explain that his reinstatement in service will hamper the DP. That finding is not it. Your finding is that on the ground of the charges frame.
First one, Lordship, gravity of the LS offense, as well as charges.
You are reading this 21(3).
Yes, third paragraph, Lordship, it
Third
comes to,
paragraph. Gravity of the offense.
yes, that is my basic trust, Lordship. And on that point, on that
No,
point,
no, gravity of the offenses in the criminal case.
as well as in the DP, Lordship.
We don't know.
The
whether these
offense
are the
LS
same
against him is a very serious nature, Lordship. That is what I
Are
am.
they the same, one and the same charges?
Yes, Lordship.
If it is one and the same, then either you proceed with the departmental proceeding,
Lordship,
or you allow the criminal proceedings to be.
no,
proceeded.
that prayer has not been accorded, Lordship.
No.
Initially, he filed one application for keeping in abeyance the departmental proceeding. That has not been granted. That is one, Lordship. And secondly, Lordship, pending criminal case can also be a reason for keeping him under suspension, Lord.
Pending criminal case on what basis?
6, Lord, Section 6, Rule 6, Lordship,
Rule 6.
discipline and appeal rules.
Yes. Rule 6(2).
I'm sorry, Lordship. No, his suspension was under 6(2), Lordship. But if Lordship comes to 6(1),
Yes.
6(1)(b),
Yes. Interest or security of the state. This is security of the state.
6(1)(b),
You're referring to 6(1)(c).
B, Lordship,
Huh?
where a case against him in respect of any criminal offense involving moral turpitude or other investigation or trial. So 6(1) gives me a reason, Lord.
6(1).
6(1)(b).
B.
Yes, Lord.
B is interest or security of the state.
No, Lord, sir. In my book, it is.
You are reading the rule as it stood earlier. New rules.
I'm holding the earlier book, Lord.
You read it. On video. You take this blue book. This one. Page number 429.
আপনার কিরকম পুরোনো হয়? Yes, Lordship. Here, Lordship, C will apply. 6(1)(c), where a case against him in respect of any criminal offense is under investigation, inquiry, or trial.
What, are you relying on any authority
Yes, my lord.
specifically on this?
Yes, my lord, 2018, my lord.
2018.
2018. 2018, 17, I think.
Pramod Kumar.
Last four paragraph, my lord, paragraph 24 to 27, my lord. But in my case also, my lord, that bail has been granted by the honorable court, my lord. And till now, my lord, we have not violated any condition, my lord.
How many years have you been under suspension?
My lord, almost 3 years, my lord. 2 years, 8 months.
What do you say, Mr. Nayak, with regard to? Pramod
Lordship,
Kumar?
on last date, Lordship, I placed one judgment, Lordship. That is 2013 16 SCC 147.
2016, yes.
Ashok Kumar Agarwal, Union of India versus Ashok Kumar Agarwal. Here, Lordship, I basically relied on two paragraphs, Lordship, 25, 26 and 27. If Lordship comes to page 164.
Yeah.
Last 8 lines of paragraph 26, Lordship. However, mere delay in conclusion of inquiry or trial cannot be a ground for quashing the suspension order if the charges are grave in nature. But whether the employee should or should not be continue in his office during the period of inquiry is a matter to be assessed by the disciplinary authority concerned, and ordinarily the court should not interfere with the orders of suspension unless they are passed in mala fide and without there being even a prima facie evidence on record connecting the employee with the misconduct in question. Then 27, Lordship. Suspension is a device to keep the delinquent out of the mischief range. The purpose is to complete the proceedings unhindered. Suspension is an interim measure in an aid of disciplinary proceeding so that the delinquent may not gain custody or control of papers or take any advantage of his position. More so, at this stage, it is not desirable that the court may find out as to which version is true when there are claims and counterclaims of factual issues. The court cannot act as if it is an appellate forum, rehearse the powers of judicial review. So this is my case, Lordship. But there are other cases also, Lordship. Lordship, there is a full bench judgment passed by the Madras High Court, wherein after discussing all the judgments passed by the Honorable Supreme Court, several constitution bench judgments, ultimately the Madras High Court full bench held that this Ajay Kumar Chaudhary judgment is not a binding judgment. There the law has been discussed, Lordship. Lordship, I am not to the ultimate finding that is there, although it's a full bench judgment, Lordship.
Water has flown after Ajay Kumar Chaudhary. There are several other judgments.
At least 8-10 division bench judgments are there, Lordship, of different high courts are there. But so far as our high court is concerned,
So
Lordship.
now you see what we go by what is there in the record.
Yes.
Or available. He was arrested, you put him under suspension. 6.
Yes.
He comes out on bail, you review his suspension, you find not a good ground to revoke suspension. He comes into the court says it is ground not good, subject to extensions been granted in 50 days. But fact of the matter is that while granting extension, suspension, why the person is required to be kept under suspension? Because you read in the judgment which we have referred to, read para 20, you have read para 27.
26 and 27.
27, that it is an aid in a process to complete the departmental proceeding.
Yes, Lord.
Therefore, you keep him out so that he doesn't interfere with the proceeding.
Yes.
Here is the case where the proceedings have not even been effectively started. No cause issued, this issue, that issue, reply filed, but the relevant papers and materials for which you'll have to initiate the proceeding, where he may have to be given the opportunity to be confronted with the record, are not available. They are under the custody of the investigator.
Lordship.
Now, there is also no finding that revoking the suspension, considering his conduct or previous record, there is a strong possibility that he may influence the investigation also, if he is in the open. No such finding. So, what for are you kept him in suspension? You do have the power to keep him under suspension, but for which there must be genuine reason. This is what?
Yes.
Which is against the respondent. The question which we want to put to the petitioner is, you see, what we are considering here now is only the extension.
Yes.
Original suspension order, court has declined to.
I was about to come to that
My
point
lord,
of also.
Court has declined to interfere.
Here only the extension is under challenge.
The extension, provided it is given under 15 days.
But that's subject to the passing of a region order, my lord.
No, subject to the passing of a reasoned order.
Yes, my lord.
Will require a finding.
Yes, my lord.
That matter has been disposed of. Whether the reasoned order is correct or incorrect is to be decided, perhaps ought to have been decided in the same proceeding.
My lord, for a moment, my lord, if I go to that, my lord, 74, my lord.
Yes.
It's 74, my lord.
Yes.
May I read, my lord?
Yes.
Upon hearing the learned counsel for the parties and taking into account that a memorandum of service was issued on 29/12/2022, and the petitioners has also submitted a reply on 6/1/2023, and the disciplinary proceeding is presently going ahead with the criminal proceedings. My lord, on that day, my lord, it was that, my lord, that departmental proceeding was going on, my lord. This court does not find any justifiable ground for interference with the suspension order. However, it is made clear that it is the mandate of the law that there has to be an extension of the suspension order by a reasoned order, who is, as per office memorandum dated 4/2/2020 is to be done within a period of 6 months. Taking into account that the learned counsel appearing on behalf of the petitioner number 1 submits that the same would be done within a period of 15 days from today, this court is not inclined to interfere with the order of suspension or the further continuation of suspension, subject to the respondent authorities passing a reasoned order within 15 days from the date a certificate of so is served upon the Commissioner GMC.
When was the reasoned order passed?
It is within the 15 days.
Within 15 days.
15 days, but
So
though not indicated that that order has been passed in as per the order of this court. But my lord, so while my lord, if lordship agreed or that that order is not a reason order, then
reason, not reason will come later.
yes, my lord.
First, let us understand the findings of the coordinate bench.
Yes, my lord.
Coordinate bench had clearly held two things. Number one, disciplinary proceedings going ahead with the criminal
Criminal
proceeding.
My lord.
So disciplinary proceedings is going ahead,
Yes, my lord.
meaning giving or perhaps to mean that it is going in right understand within the required period of time it should be completed.
Yes, my lord.
What is evident now,
No.
the proceeding, is there except other than issuance of a show cause, appointment of an inquiry officer, presenting officer, you're filing a reply, even the relevant files are not available. So therefore, the process of going ahead with the proceedings, perhaps in the next immediate future, we don't see, unless the files are retrieved from the investigating agent.
Right.
But this is the finding arrived at. Finding is bound to be arrived at by the court correctly on the materials or submissions made. Then the court is disinclined to interfere with the suspension order subject to the authorities passing a reasoned order.
Yeah.
You are putting stress on the reasoned order,
Yeah.
but perhaps the order lays stress on the period of 15 days. If this order is passed within 15 days, no interference. And it is admittedly passed within 15 days.
No, my lord, that order is passed within 15 days.
15
But
days.
my lord,
It is a prima facie, it is a reasoned order. Whether the reason is sufficient or not is a different question.
no, my lord,
But assuming we interfere to say that these reasons are not germane for extension, we are still confronted with the findings of a coordinate bench that the court was disinclined to interfere with the order. This order is
my
not
lord,
under
my
review.
lord,
or
if
appeal.
it, if my lord, not if my lord, if it is not a reason order, and my lord, and my lord, if your lordship
No,
exercise,
let us be clear on one thing.
yes, my lord,
There are two things to say. One is a reasoned order,
yes, my lord.
and another thing to say these reasons are not sufficient. What you are addressing before the court is that the reasons are not sufficient.
Yes, my lord,
And therefore, it is not a reasoned order.
yes, my lord, yes,
Prima facie, it doesn't appear to be not an order which does not have any reason.
my lord.
It has got some reason.
My lord, so far reason order means, my lord, that substantive reason should be there, my lord.
Reasons are there.
So my lord, 15/6,
Now,
2020.
assuming we interfere this
No, my lord.
extension, what happens?
My lord, my lord, 15/6/2000 order.
Mr.
Yes,
Verma, supposing we interfere with this extension, what happens? Matter goes back to the authority to pass another reasoned order. Can we interfere with the suspension order in view of the categorical finding by the coordinate bench? We are not sitting in the people.
No, my lord, when my lord, when my lord, that extension order will go, my lord, if, my lord, then automatically, my lord, lordship, that my lord, suspension order will also go.
There has to be a
But
finding.
it is a consequential, my lord, extension.
Be a finding. So much of interpretation could not have been called for had this observation of the coordinate bench not
And
been
my
there.
lord, coordinate, my lord, my humble submission would be, my lord.
See, coordinate bench has not declined to interfere with the suspension on any other ground except for the fact that disciplinary proceedings that are going ahead. That's the finding.
Though my lord, the coordinate bench have not, my lord, put the word that at this stage, my lord, but plus subject to the, my lord, passing of a reason order, my lord.
The hypothetically, if
Yes.
the disciplinary proceedings would have carried on a date when this order was passed, which is on 24/5/23. It's 2 years now.
Yes.
It would be logically, it could have been assumed that the disciplinary proceeding would have concluded. Matter would have gone before the disciplinary authority, either accepting, rejecting, or passing any order. Then the question of further suspension, not suspension, would have been done. Here is a case with effect for the last 2 years.
Yes.
No proceeding is gone. And the rules are very categorical. They are within their powers to keep you under suspension.
Yes. But my lord, as my lord, so far, my lord, the department, no hope that my lord, it will be completed within the period of 3 months, 6 months.
No,
my lord.
but that is not the question before the court.
Yes, my lord.
Question before the court is not that the disciplinary proceedings are dragging on endlessly.
Yes.
This is not the prayer you are.
And my lord, 2018, my lord, Apex Court has all
18
elaborately, my lord, deal with that issues, my lord.
18 judgment is there. You have to read it with the earlier 16 judgment or
Yes.
what 21 judgment, whatever judgment is there.
So, my lord, 2018, my lord, Apex Court has elaborately deal with that issues, my
Assuming
lord.
we accept your submission,
My lord.
what happened? Extension order, let us say we allow the petition, extension order goes. What happens next? They are entitled to, the matter has to be remanded back for passing a reasoned order.
Not my humble submission would be, my lord, that my lord, if lordships, my lord, decide that order, my lord, then my lord, automatically it's
We set aside, assuming we accept your submission and set aside on the ground that it does not have the reason.
my lord.
They are entitled to be given an opportunity to pass a reasoned order. Even otherwise, under 6(1), they are entitled to keep you under suspension in terms of Ojit Sunwal.
Yes. And my lord,
Sunwal judgment clearly says that even 6(2) suspension, if it comes to an end, then during the process of disciplinary proceeding, they are entitled to keep you under suspension. if they desire
and my
and
lord, in the meantime, my lord, 2 officials, my lord, those are deputed in my lord DMC, they have been reinstated, my lord.
Where are those orders? These orders are available here?
Yes, my lord. I am annexed, my lord. My lord, before that, my lord, lordship kindly come, my lord, page 185, my lord. My additional affidavit, my lord.
Yes.
My lord, 183, my lord, last paragraph, my lord.
183.
183, my lord, last paragraph. In this instant, case to the arrested accused person, so and so, then my lord Asif Ahmed, Prostata officer and Abhimanyu Medi, accounts officer, would prepare the strategy for misappropriating government funds and engage the rest of the government officials as well as the firm to siphon out the money for their own pecuniary benefit. All of them criminally so and so. Then my lord, lordship kindly come to the.
Where are the orders?
Then my lord, 188, my lord.
188.
12 December 2024. Without prejudice to the departmental proceeding that may be drawn, the following officer in the rank of executive engineer under irrigation department.
They are reinstated by the parent department.
Parent department, my lord.
You are also on deputation.
No, my lord. We are from DMC, my lord. But my lord, in the search sheet, my lord, that my lord, this Asif Ahmed, my lord, he was the my lord, he's the one of the main accused, my lord. And secondly, my lord, that financial officer, my lord, he was also reinstated, my lord. It is, my lord, page 196. Page 196, my lord.
Where are the charge sheet? Charge sheet.
Charge sheet, my lord, page 91, 92, my lord. 93, sorry, 93.
We'll come back at 2.
Yes.
Extension.
Yes, sir.
Is it the only extension or are you required to
Last one was in the month of March 2025.
March 25?
Yes, loose copy I have furnished.
So when is the extension again?
21/3.
21/3/2025.
That is the last.
Yes.
Then you are required to review the extension again.
Lordship, this order 20, this is an order, Lordship, wherein it was extended until further order.
No. So does it mean that it doesn't require any review?
Uh, It's just crossed 3 months, Lord. 21/3 means it.
When the first order was issued on 15/6/2023, my lord.
23. Then
And
next
subsequently after almost 2 years, my lord, 21/3/2025, my lord.
Oh.
No periodic review, my lord.
You are required to review, I think, under that OM.
Yes, my lord.
Within 6 months.
Lordship, no, Lordship, in that way, Lordship, that's within 6 months is the second review, Lordship. First one immediately after issuing of source sheet, and secondly, after 6 months, I have to do the review again.
So that's right. But
Yes.
after that, are you saying that no review is called for?
Lordship, probably required, Lord. Now, in this case, Lordship, it was on 21/3/2025.
Correct. Then next review,
That instruction I have to take, whether any further review made or not,
bound to take, have to be there.
Lordship.
Lord, page 70, my lord, OM, last paragraph, my lord. OM, my lord. Page 70, my lord.
70.
Yes, ma'am. Last paragraph. ma'am.
Yes.
All the departments will submit quarterly return to the personnel B department with details about the suspension order, issued memorandum of charges, served upon the delinquent officer employed, if any extension of the suspension period is given, etc. The personnel department will compile the report received from all the department and place before the undersigned for a periodical review every 3 months of the last 3 months suspension order for further necessary action. Normal periodical review should be made after 3 months, my lord. My lord, that's why, my lord, that 15/6/2023 order is one of the prima facie bad, my lord. My lord, it is until further order, my lord.
Okay. Hear the order.
And my last order, also, my lord, latest order, 21-3, my lord, it is also, my lord, up to until further order, my lord. Page 195.
Right, heard. The council to keep this petition directed against the.
Lords, I'm placing just one more judgment, Lords, on the same thing. On delayed delayed
Dated
DP. Lords.
15/6/2023. No, the law is clear. You may place one judgment or 10 judgments.
No, my submission will be Lordship. So far as this petition is concerned, it's central around only on the issue that extension order is not a reason order.
Correct.
So delayed period of departmental proceeding is not before.
That's right. That's right.
Lordship
So
may
therefore we said
definitely
you hear
consider.
the order.
Yes, that is not the issue. That is not the grievance of the petitioner.
You hear the order. Wait for the court to dictate the order first.
Lordship.
But the petition is directed against the order dated 15/6/2023 issued by the Commissioner BMC, whereby the petitioner was placed under suspension. Whereby the petitioner's suspension stood extended until further order. What is the, you are challenging this page 81 order?
Two order, my lord, suspension as well as, my lord, extension, my lord, region extension order, my
Where is the suspension order? Where is the suspension order?
Is 51, Lord.
51.
You write to challenging the order dated 24/10/2022, whereby the petitioner, along with 4 other persons, were placed under suspension with effect from 24th of October 2022, as well as the order dated 15/6/2020. The suspension stood extended. Stop. The petitioner is serving as an executive engineer under Guwahati Municipal Corporation. And he was placed under suspension with effect from 24/10/2022, pursuant to his arrest on 21/10/2022 in connection with Elan's case number 04/2022. Subsequently, he was granted bail on 19/12/2020. So, of the pleadings available on record, it is seen that the charge sheet. Which charge sheet is referred here? 11/1 is what charge sheet?
It's for a criminal case.
Charge sheet in the criminal proceeding where it was filed on 11/1/2020. So, the criminal proceedings is pending disposal before the competent court of. So, petitioner was served with a show cause notice on 29/12/2022 by the department, to which he filed a reply on 6/1/2023, denying all the charges. Since the suspension was not withdrawn, in spite of the reply being filed, petitioner approached this court by filing WPC number 2883 of 2023 on the ground that no review or extension was made after expiry of 90 days, and which is in violation of the principle of law, violation of the law laid down in Ajay Chaudhary versus Union of India reported it. So, this court, by order dated 24/5/2023, disposed of the writ petition, however declining to interfere with the suspension order. Passed. Stop. However, the court directed the respondent authorities to pass a reasoned order within 15 days from the date a certified copy of that order is available. In deference to the directions passed by this court in WPC number 12, the impugned order dated 15/6/2023 was passed, whereby the suspension of the petition stood extended. So, whereas the learned counsel for the petitioner submits that the petitioner has been placed under suspension for a period of almost 3 years. Stop. Although the departmental proceedings have been initiated, however, pursuant to issuance of the memo of charges to which the writ petitioner filed a reply, the disciplinary proceedings have not progressed any further. Stop. The respondents, the learned counsel for the petitioner submits that the proceedings have not progressed in view of the fact that all the relevant records are filed on the basis of which the departmental proceedings have been initiated against the writ petitioner are under the custody of the Chief Minister's Vigilance Cell in connection with vigilance case number 12. Stop. There is no response received from the investigating authority as to when the files would be returned back. And as a consequence thereof, there is a complete uncertainty with regard to the progress of the disciplinary proceeding. So it is submitted that when the departmental proceedings have not progressed against the petitioner, and the relevant records and files are also under the custody of the Vigilance Department, the continuance of the petitioner under suspension is totally unwarranted, and therefore the same should be set aside and interfered with. So it is further submitted that the coordinate bench by order dated 24/5/2023 had although declined to interfere with the suspension order, but directed the respondents to pass a reasoned order within 15 days from the date of receipt of a certified copy. Stop. Although it is not reflected in the impugned order dated 15/6/2023 that this order is passed in deference to the order dated so and so passed in WPP so and so. The authorities extended the suspension of the petition However, the same are not supported by adequate reasons. So consequently, the petitioner is aggrieved that the extension of suspension as permitted, extension of suspension undertaken as have been permitted by the court by the earlier order dated with WP Swenson was undertaken without proper reasons. So the only reason discernible from the order is that the relevant records and files were taken by the concerned officials of the Chief Minister's Special Vigilance Cell, and the same are still in the custody of the Vigilance Cell. So it is submitted that under such circumstances, the prolonged suspension of the petitioner is totally uncalled for and should therefore be set aside, quashed. In support of his contention, the counsel for the petitioner has relied upon besides the judgment of the Ajay Kumar Chaudhary reported in Swenson, the judgment or the apex court rendered in Pramod Kumar reported in 2018-17 SCC 677. So, pressing the state judgment into service, the learned counsel for the petitioner submits that pursuant to the petitioner being pressing the judgment into service, the counsel for the petitioner submits that the extension of the suspension of the petitioner is not supported by the reasons which require prolonged suspension of the petition. So it is further submitted that this extension is in violation of the office memorandum dated Fourth of February 2020, whereby the government of Assam has laid down a procedure for review and extension of suspension required to be carried out by the department against Delhi. So, any other judgment you are relying on? Pramod Kumar and
Regarding reason order, I have three that reason order.
you have submitted some. The counsel for the petitioner has also referred when relied upon the judgment of the apex court rendered in Chandra Nandi, reported in 2019 4 NCC 357. Support his contentions that judicial and quasi-judicial orders passed by court/tribunal or authority concerned, which decides the list between the parties, must be supported with reasons in support of the conclusion. So, referring to the said judgment, the learned counsel for the petitioner submits that since the impugned order does not justify the reasons for a continuance of the extension of the suspension of the petition, the impugned extension is bad, say, be set aside. Watch. In support of the same content, in support of the same contention, the further reference is made to the judgment of Aniram Duhar, reported in 2004 5 NCC 568. N, N, PIR 2021 SC 2396. Within bracket, Vibhu Prasad Sarangi. Others. He therefore submits that the impugned extension of the suspension of the writ petitioner is valid law and would say that it's a and apart from her physical denied, rather than being strongly disputed the content of the brief by submits that there is no question of challenge made to the suspension order in as much as by the earlier order dated when no part of the court had read the as per the earlier order dated when no part of the court had read that clearly rejected the clearly was clearly declined to interfere with the suspension order in view of the gravity of the offences alleged against the writ petitioner, but giving liberty to the respondents to pass an order of extension within 15 days with reason for law. The learned additional lady submits that the impugned order dated going to impugned order dated 15/6/2023 cannot be said to be bereft of any reason. The reasons are very clear in the recital of the order, and since the records and relevant files are still in the custody of the Chief Minister's Special Vigilance Cell, the suspension was required to extend. So once these relevant documents are received, documents and papers are received from the Chief Minister's cell, the department will be to proceed with the inquiry and if required, the further review of the continuance of keeping the further review of the requirement of keeping the petitioner under continued suspension can be taken. So it is submitted that where the suspension order dated was not interfered with by the court bench, any interference of the subsequent extension order will not amount to interfering, cannot amount to interfering with the order of suspension. So, you want to submit something?
Yeah, the first judgment or Ashok Kumar Agarwal is there, Lordship. Second, one more judgment, Lordship. This is 1998 4 SCC DDR. 1998 4 SCC 154, one paragraph only, Lordship. That is paragraph 19. It's a balanced judgment, Lordship. Paragraph 19.
Are the other unbalanced?
No. Lordship. It covers both the sides, Lord.
Yes, paragraph?
Paragraph 19, Lord.
19. Yes.
It is not possible to lay down any predetermined principles applicable to all cases and in all situations where there is a delay in concluding the disciplinary proceedings. Whether on that ground the disciplinary proceedings are to be terminated, each case has to be examined on the facts and circumstances in that case. The essence of the matter is that the court has to take into consideration all the relevant factors and to balance and weigh them to determine if it is in the interest of clean and honest administration that the disciplinary proceedings should be allowed to terminate after delay, particularly when the delay is abnormal and there is no explanation for the delay. The delinquent employee has a right that disciplinary proceedings against him are concluded expeditiously and he is not made to undergo mental agony and also monetary loss when there are unnecessary prolonged without any fault on his part in delaying the proceedings. In considering whether the delay has vitiated the disciplinary proceeding, the court has to consider the nature of surge, its complexity, and on what account the delay has occurred. If the delay is unexplained, prejudice to the delinquent employee is writ large on the face of it. It could also be seen as to how much the disciplinary authority is serious in pursuing the searches against its employees. It is the basic principle of administrative justice that an officer entrusted with a particular job has to perform his duties honestly, efficiently, and in accordance with the rules. If he deviates from this path, he is to suffer a penalty prescribed. Normally, disciplinary proceedings should be allowed to take their course as per relevant rules, but then delay defeats justice. Delay causes prejudice to the search officer unless it can be shown that he is to blame for the delay or when there is proper explanation for the delay in conducting the disciplinary proceedings. Ultimately, the court is to balance these two diverse considerations. The Lordship, here the suspension was not under silence. Here the disciplinary proceeding itself was under silence. And I am only relying upon the principle that has been laid down in the particular judgment. Two things, Lordship. Again, one is the gravity of the offense and the reasons for delay, Lordship, if it has been properly explained or not. In my case, Lordship, if Lordship comes to the search sheet annexed with the additional affidavit, only 3 paragraphs I would like to show.
On that. We are not here to be looking into the charges or you proceed. We are not restraining you.
Lordship.
We are not restraining you, but you have no explanation for the record not being available. You have to find out a way to proceed or not to proceed.
No, in my affidavit, Lordship, it has been explained because of this particular reason, we are unable to
Then
continue.
you have to explain why the petitioner continued suspension is required.
Because of the grave searches, Lordship. That is why I'm trying to just 1-2 paragraph in the search sheet.
Suspension is not a punishment.
Yes.
It cannot be used as a punishment. The charges are charges. It has to be
Lord.
proved.
Lordship.
Unless it is proved, he is an innocent person. So merely because the charges are there, I can understand that yes, these are grave charges. The files are there. He will have access to the office. Therefore, that's the only reason for suspension. Or you transfer him to some other place where he does not have access. But the charges are in the criminal court. Files are with the investigating authority. Nothing is there in your office. You have admitted in your office. Yet, because of the charges, you want to keep him suspended. For what purpose? What purpose will it serve? It can be used as a punishment.
Not as a punishment, Lordship, but it is my submission, Lordship. It is in terms of the rules, Lordship. Rules allows me to keep him under suspension. That is one.
But then you have to give a reason. Rule.
And secondly, Lordship.
One could have understood that
Yes.
you have started off with the disciplinary proceeding. At the instance of the petitioner, the proceedings could not go ahead. He's taken time, he's not well, or he's arrested, or disappeared, or something happened, or he's unable to find the necessary documents, or he's not getting witnesses, he's not coming for cross-examination.
Yes, Lordship.
Then
Probably.
there is a delay.
Yes,
which
the
is
delay.
attributable
No,
to the
it is not that, Lordship. We are not trying to recover the files or recollect whatever it is with the vigilance. Lordship, what I'm submitting, Lordship, the departmental proceeding has not yet stopped. It is going on. And it is very recent when we have appointed one IO and one PO, Lordship. It will continue.
PO will do what? Unless
Like at this stage, Lordship, if it is interfered with or he is reinstated, Lordship, Probably tomorrow, day after tomorrow, we'll get the files back, Lordship.
You are not precluded from taking proper action under
Yes.
the.
In that situation, Lordship, his continuance in the department may definitely,
The rules are clear on that aspect. You are supported by a judgment of a division bench of this.
that is there.
verdict.
That is there.
So, all right, Mr. Nayak. In support of the referred to a judgment. Take note, referred in 2013 and 147. Wherein he submits that that the suspension order can be passed by the competent authority, considering the gravity of the alleged offences. That is the seriousness of the act of omission or commission and the nature of evidence available. Effect on public interest due to the petitioner's continuance in the office is also relevant and determinant factor. These factors will have to be taken into consideration as no formula of universal application can be laid down in this regard. But he also refers to judgment of the Apex Court AP versus N. Radhakrishnan reported in 1998 for SSC 154. What was the paragraph here?
19, Lord.
This recent judgment you
Yes, just now I read paragraph 19, Lord.
Paragraph
19, 19.
19.
What I'm basically submitting, Lordship, delay is there, but delay has been explained. That is my.
He submits that that the court has to consider all relevant factors and to balance and weigh and determine them. See if it is in the interest of clean and honest administration that disciplinary proceeding should be allowed. Where the delay has been properly explained and the reasons why the delay has occurred in the conclusion of the disciplinary proceeding, this court ordinarily should not interfere with the extension of the suspension. That is your submission?
Yes, Lord. Yes.
Fair enough. Learned counsel for the parties have been heard, meetings available on record, have been kept, Peru's judgments pressed into service have been noted. The petitioner was placed under suspension under regulation 6.2, rule 6.2 of the Discipline and Appeal Rules 1964. The suspension of government officers to be carried out under the rules of 1964 are prescribed under Rule 6. For the purposes of this case, the reference to Rule 6.1 and 6.2 would be relevant. The same are extracted below 6.1, 6.2. A perusal of the provisions revealed that the government is authorized to place a government servant under suspension under Rule 6.1 when there is a disciplinary proceeding against him contemplated or is pending, or where the opinion of the authority, in the opinion of the authority, the delinquent officer has engaged himself in activities prejudicial to the interest or security of the state, or where a case against him in respect of any criminal offense is under investigation, inquiry or trial. So, however, in the present case, there is no dispute that the petitioner was placed under suspension under Rule 6.2, which is evident from the order of suspension issued dated 24/10. It's not under 6.2.
This is not mentioned.
It's not under
It is
6.2.
not that.
All right, petitioner was placed under suspension pending royal of
Departmental.
disciplinary proceedings.
That is 6-1, Lord.
Huh?
Pending royal of departmental proceeding is 6-1.
Dated 24/10/2022. Stop. From the order, it is apparent that the petitioner was not placed under suspension in terms of Rule 6.2. This is the suspension order 51.
Yes.
It is not under 6.2. So,
Language is 6-1, Lord.
pending royal,
Yes,
not for he taken into custody.
Yes.
not deemed suspended.
So, the law with regard to the prolonged suspension and continuation thereof has been elaborately dealt with by the apex court on several judgments. So, the parameters for continuation of suspension has been laid out by the apex court in Ajay Chaudhary reported in 2015. The apex court in said that had laid down the parameters which are expected below para 21, 22. In the facts of the present case, in view of the vigilance case, which was initiated against the petitioner and other persons, the petitioner came to be placed under suspension pending royal of department proceedings. The although the department has served the charge memo, the show cause notice on the delinquent officer, which the officer has also filed his reply, and consequently the inquiry officer and the presenting officers have also been appointed. The departmental proceedings have not been able to proceed further as the relevant files and records and papers on the basis of which the proceedings are required to be initiated against the petitioner are still in the custody of the Chief Minister's Vigilance Cell, and the papers have not been received till date. So, it is not in dispute that the delay that has occurred in the progress of the departmental proceeding can be attributed to the delinquent as in spite of the show cause notice served and the reply file, as well as the inquiry officer and presenting officer being appointed, proceedings have not commenced further in the absence of the relevant report statement and files being made available to the department. Stop. In spite of counter affidavit being filed and opportunities being granted to the respondents, the likely the period likely to be undertaken by the department is not before the court, since the reports are admitted or received by the department. In the context of the judgment which are referred to, in Pramod Kumar versus so and so, Union of India versus Pramod Kumar, the apex court interfered with the prolonged suspension on the ground that there is no material before the court to suggest that during the release of, during the period the petitioner was on bail, there was instances of the petitioner therein attempting to tamper with the evidence. Stop. The apex court noted that the only ground for extension of the suspension of the petitioner therein was on the report, was on the basis of the minutes of the review committee meeting, wherein it was mentioned that the delinquent officer was capable of exerting pressure and influencing witnesses and misusing office if he is reinstated in office. So, in Chandra Nandi reported in so and so, Chandra Nandi Supra, the apex court held that every judicial and or quasi-judicial order passed by court, tribunal, or authority concerned, which decides the lists between the parties, must be supported by reason in support of its conclusions. The apex court held that the parties to the lease, as also the appellate slash revisionary court, while examining the correctness of the order, is entitled to know as to on what basis the particular conclusion is arrived at in the order. In the absence of any discussion, the reasons and the findings, it was not possible to know as to what led the court or the authority for arriving at the conclusion. Stop. In Dhaniram Luhar Supra, the apex court held that the reasons introduce clarity in an order. The reason is the heartbeat of every conclusion, and without the same it becomes lifeless. The reasons substitute subjectivity by objectivity. The emphasis of recording reasons is that if the decision reveals the, within bracket, inscrutable face of the Sphinx, bracket closed, it can, by its silence, render it virtually impossible for courts to perform their appellate function or exercise the power of judicial review in adjudging the validity of the decision. Stop. Right to reason is an indispensable part of a sound judicial system. Reasons at least should be sufficient to indicate an application of mind to the matter before the court. In Vibhu Prasad Sarangi, it was again held by the apex court that the reasons constitute the soul of judicial decision. Without them, one is left with a shell, and the shell provides neither solace nor satisfaction to the litigant. Stop. Insofar as the judgments referred to by the respondents are concerned in N. Radhakrishnan, Supra, the apex court, while examining the delay in conclusion of a departmental inquiry, held that the court has to take into consideration all the relevant factors and to balance and weigh them to determine if it is in the interest of clean and honest administration that disciplinary proceedings should be allowed to terminate after delay, particularly when the delay is abnormal and there is no explanation for delay. It was held that delay causes prejudice to the charged officer unless it can be shown that he is to blame for the delay, or when there is proper explanation for the delay in conducting the disciplinary proceedings. Ultimately, the court is to balance these two diverse considerations. In Ashok Kumar Agarwal, Supra, after examining the various earlier precedents of the apex court, it was held that suspension order can be passed by the competent authority considering the gravity of the alleged misconduct, that is, serious act of omission or commission, and the nature of evidence available. It cannot be actuated by malice or arbitrariness or ulterior motive. Effect on public interest due to the employee's continuation in office is also relevant and a determining factor. However, suspension order should be passed only when there is a strong prima facie case against the delinquent, and if the charges stand true, would ordinarily warrant imposition of major punishment, which is removal or dismissal or reduction in service. Stop. Better. After noting the judgments cited above, it is clear that there is no quarrel with the proposition that the department has the power to keep an officer, delinquent officer, under suspension, keeping in view the allegation, keeping in view the nature of the gravity of the offences alleged, and if the authorities of the view that there is a substantial authorities of the view that in the event the charges are proved, it will amount to major punishment. So, stop. Insofar as the petitioner is concerned, the charges is leveled against the petitioner are, as per the charge sheet, are expected below. Page number 83 and 84. Stop. These charges have been replied to by the petitioner. However, as have been discussed above, in the absence of the relevant reports, papers, and file, the proceedings have not been continued, notwithstanding the petitioner being placed under suspension. It is also submitted by the counsel for the petitioner that the other 4 officers who were on deputation to the GMC have in the meantime been reinstated by in their posts by the parent department.
One of 2 officers.
2 officers. Out of the 5 officers, 2 officers. Stop. The order of extension dated 15/6/2023 reflects the only ground that the petitioner is required to be suspended. The petitioner's suspension is required to be extended as the relevant official records, documents, files are under the custody of the Vigilance Cell, Chief Minister's Vigilance Cell. The impugned order dated 15/6/2023 also reveals clearly that the departmental proceedings have been deferred until further orders. And under these circumstances, the petitioner's suspension was extended. Stop. Pursuant to this, any other order? 15/6?
21.
Any other order after 15/6?
Yes, Lordship, 1/21/3/2025.
Subsequently, 21/3. Subsequently, the authorities have issued another order.
Page 195.
It is there, 195. Dated 21/3/2025. On the same grounds, namely that the records and files of the department are still in the custody of the Vigilance Cell in connection with Vigilance Police Station case number 4 of 2022. And the process of procuring these files is underway. And consequently, the petitioner's suspension was extended. Stop. The subsequent order dated 21/3/2025 does not reveal whether the postponement or the deferment of the disciplinary proceedings have been. The subsequent order dated 21/3/2025 also does not disclose the status of the disciplinary proceedings. Stop. However,
Just one line, Lordship. In my affidavit, page 209,
no, in the order 195,
Lordship, another order is there. That is also 21/3/2025,
page number
209, Lordship.
09.
Paragraph 4, Lordship. Whereas the authority now intends to proceed further with the departmental proceeding, and as such, the decision for deferring the departmental proceeding is hereby withdrawn with immediate.
Subsequently, on the same date, another order dated 21/3/2025 was issued, whereby the decision of deferring the departmental proceeding was withdrawn with immediate effect, and the inquiry officer and the presenting officer are appointed, who were appointed, were directed to continue with the departmental proceedings and conduct the inquiry into the charges framed. Stop. Under such circumstances, what is evident is that, as fairly submitted by the additional AG, that the files, relevant records have not yet been received. What is the status?
One later dated 16/6/2025. That is the last one, Lord. And again, a prayer was made before the.
But it has not been received.
Not yet received.
As per instructions, that although the prayer is made for receipt of the records, the
second paragraph,
the relevant records have not yet been received. Stop. Fair. Having given anxious thoughts to the facts evident as enumerated herein above, as well as the law enunciated by the apex court, as well as the rules, you see that the department is within its power based on inter alia in contemplation of departmental proceedings. The proceedings have been initiated. The inquiry officer and presenting officer has also been appointed. However, as discussed above, in the absence of the relevant records and files, the proceedings have not been able to be carried on. And notwithstanding that, the petitioner continues to be under suspension. It is well settled and no longer resignated that suspension is not a punishment. It cannot be used by the authority as a means to punish an officer, delinquent officer. Till the time the charges are proved, the officer innocent. Till the time the charges are proved, the officer cannot be held guilty. So, what is also apparent from the pleading that the charges framed against the petitioner, the departmental proceeding. And where is the charge sheet? Charge sheet? Charge sheet?
Charge sheet, my lord, page 93, my lord.
What is evident from the pleadings available on record that the charges, charge sheet framed against the petitioner in the vigilance case number so and so is the basis on which the show cause and the charges against the petitioner are framed. So, there is no quarrel with the proposition that both departmental proceedings and criminal investigations and trial can proceed independently. However, when they're based on similar charges, there have been instances where till conclusion of the criminal proceedings, the departmental proceedings are kept on hold. So, in the present proceedings, this question is not required to be decided by the court. What is required to be decided is the grounds and reasons whether can be considered to be germane for extension, continued extension and prolonged suspension. The reasons for extension or suspension and the non-conclusion of the departmental proceeding from the pleadings available on record cannot be attributed to the so it is evident that the proceedings could not be completed because the relevant records and files are not equal to the authority concerned, as the same are not received back from the state or namely the CN 11. So, there is also no finding in the extension report, extension order that as to the grounds, as to the, as to as to the reasons otherwise than dependency of the department keeping the petitioner under suspension. There is no allegation that the petitioner will misuse his office for influencing any witness or tampering any evidence, either during the proceedings or in the trial. No such finding is discernible from the extent order passed by the authority. Under such circumstances, this court is inclined to hold that the extension of the petitioner and his continuance in prolonged suspension is on the grounds which this court does not find justiciable as the only ground for keeping the petitioner under suspension is that the departmental proceeding not be concluded when the same same could not be procedurally as the relevant record that files have not been received. from the CM's vigilance report. Under such circumstances, the court does not consider the necessary, does not find the extension order dated when justified and supported by the for prolonged extension. The orders therefore can interfere with and set aside. The petitioner shall be reinstated in service. of the Petitioner shall be reinstated in service as the extension of the suspension has been held to be valid by this court. So, the setting aside an interference of the extension order will, however, not curtail powers of the department to invoke the residual powers available under the provisions of Assam Discipline and Appeal Rules, pass appropriate orders if it thinks fit during the currency of its writ petition allowed. Is there any interim order?
No.
No order is disposed.
Obliged for the present hearing. Lordship, I'm just praying for one observation only. It's only a reinstatement, but suspension order is there. I mean, the consequences of suspension will be there, but he is going to, or Lordship has passed on direction for his reinstatement. That is what-
Reinstatement.
Yes. So consequences of suspension will be there.
What is the consequence?
The original suspension order will be there,
Ah.
but Lordship has directed to for his reinstatement. That is what I understand.
That original suspension is qualified by the extension.
Yes. So
Otherwise-
extension has been, I mean, Lordship has rejected.
Because the original suspension order has spent its force after extension.
Yes.
If the order is passed, you extend it. Then the original suspension order and the extension order
Yes, understood.
continues.
I'm only trying to clarify, Lordship, from which date his reinstatement will take place.
Reinstatement will take place with effect from today.
Yes, Lordship, kindly clarify that, Lordship, that is one. And secondly, Lordship, I'm praying for one liberty. When the disciplinary action against picks up, Lordship will grant us liberty to proceed as per the rules, Lordship,
Yeah.
as regard his suspension.
So we have indicated that.
Lordship, obliged.
We have indicated.
Obliged.
We are not saying that you can place him under suspension or don't place him under suspension. We said you have powers available under this act to proceed accordingly as per law.
No, why I'm trying to clarify, Lordship, because already I have suspended him once. In case of Ajit Chunwal, Lordship, initially it was 6-2, subsequently it was 6-1.
So we are interfering with on the grounds and reasons given there.
Lordship.
That is a prolonged suspension. Once you proceed, if you think that it is necessary to suspend, you must have the reason.
Yes.
To keep him under suspension. There must be reason. It is not automatic that because you are proceeding on departmental proceeding, he is automatically to be placed under suspension. The purpose of suspension is to keep him away.
Lordship.
You have all along kept him away without going ahead with the suspension.
Lordship.
The two petitioner, one superintendent is there, one assistant executive engineer.
How many petitioners are there?
Three.
Three.
Yes.
All on similar dates are similar.
Dates are similar. Suspension order is same. Extension orders are also similar.
Designation is the same.
You give us a
Yes.
short date,
Yes.
order of suspension, extension, and the
Designation.
three writ petition disposal.